Good morning. This is Renee Line, Chair of the Colorado Real Estate Commission. Today is February 3rd, 2026. It is 9 a.m. This is a public meeting of the Colorado Real Estate Commission. We will now call this meeting to order. Let's begin by having Director Waters perform roll call.
Renee Lind.
Here.
Erica Sanders.
Here.
Bernadette Bugarin.
Here.
Erica Doyle.
Here.
Autumn Rubal.
Here.
You have a quorum.
Okay. And David, do you want to do the CE?
Thank you, Madam Chair. Good morning, everyone. For members of the public, if you are seeking continuing education credit for today's meeting, I would request that you please select or answer the poll here that we've popped up on the screen and submit your information to us. And then within a few days after today's meeting, we will deliver those certificates out to you. If anyone has any issues with the poll or doesn't quite complete it in the time that it is available here, please do not hesitate to reach out directly to me at david.donnelly, DONNELLY @state.co.us, and we will get you added to the list, provided that the meeting lasts the requisite time as required by the rules, and that your attendance, in fact, also meets that standard. So with that, chairs, I'll pass it back to you and for the next matter on the agenda. Thank you very much.
Okay, well, that is up and people are registering. We'll take a look at the minutes. Do we have a motion to approve the board meeting minutes?
Motion to approve.
For December of 25.
Motion to approve the board meeting minutes for December 2025.
Second.
Yep. Okay. So there's a motion and a second. Is there any discussion? All right. All those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes. Okay, then we have public presentation of any issues not on today's meeting agenda.
Once again, board, our commissioners, excuse me, thank you. If any members of the public have any comments that they would like to bring to the attention of the board, I would request that you now select the raise hand icon in the Zoom platform, and we can identify you. And please limit your comments to 3 minutes, and also understand that that this section of the public participation is not to address any investigatory matters on today's agenda. So with that, if there are any individuals that would like to address the board, please do so by selecting that raise hand icon. However, commissioners, I'm not seeing any hands at this time, so we can hand it back to you.
Okay, the next item is commissioner training. This is Commissioner Chair Renee Line. This is a Colorado Real Estate Commission meeting being conducted on February 3rd, 2026. The time is now 9:04 a.m. I move the commission enter into executive session pursuant to Colorado Revised Statute Section 24-6-402-3A2, or to discuss confidential information pursuant to CRS 24-6-402-3A3. The purpose for this executive—
Madam Chair, sorry to interrupt. So our vision was to conduct this training in the public portion of the meeting, and then to provide for an executive session, just in case if you'll have any questions at the end of Gina, who will be presenting first, and then I will be presenting second. So if you don't mind, can we do it this way? The public the first training will be in public, and then we will offer a chance to go into an executive session if necessary, if you will have any questions.
Okay, that's fine. I guess we'll move on to training in an open session.
And actually, commissioners, really quickly, I wanted to introduce Director Patel with the Governor's Office of Boards and Commissions. Sorry, I can't talk this morning. She is here just to join your meeting.
Welcome. Thank you. Thank you for having me.
Hello.
Well, welcome, Nikki, and good morning, commissioners. Gina Simonson, and I'm going to do the first segment of the training today. And actually, it's the other training presentation. Yes, thank you. We're going to start with the exceptions training. And again, as Irina mentioned, we're going to do this in public session, but if you have any questions along the way, just jot them down and we'll go into an executive session and we can discuss or address any of those questions following Irina's presentation. And we thought exceptions training was in order just because I think all of you have at least had some experience last year reviewing a case in exceptions, and it doesn't happen that often. And since it's infrequently encountered, sometimes it's good to just kind of give you a context and some backdrop for the exceptions review process. And so that's what this focus is. If you can change to the next slide. So as you can see from the slide, and as you are familiar with the two distinct roles that the commission performs as a regulating body, the most comfortable role and familiar role is your prosecution role. And that's sort of what you do mostly when you come to your public meetings and you're reviewing the DRE investigations and sort of making disciplinary decisions at your public meeting like this one. You review a complaint, you review all the investigative materials, and you decide as a group what discipline is appropriate for that particular case. Now, often that's the end of your role because a lot of your cases will settle. You're familiar with Penny's expedited settlement program. The lion's share of the disciplinary recommendations that you make, Penny is able to resolve at settlement, but some of them are not settled, and a limited amount will get referred to the AG's office for formal disciplinary hearings. They're the proceedings that the AGs assigned to the case will prosecute on your behalf at a formal administrative hearing at the Office of Administrative Court. My litigation team will file a notice of charges, or if it's a licensing denial case, a notice of denial. And that is when your prosecution petitioner role is at play. When we, as your attorneys on behalf of the commission, enforce a decision that the commission made at a public meeting to discipline a licensee or to deny an application for a license. And that is, again, the role that you're most familiar and comfortable with. The one that you haven't had a lot of experience is your adjudicatory role. And it's a big word to say. It's a quasi-judicial role. And the purpose of the adjudication, or your role as an adjudicator, is to review an administrative law judge or an ALJ's initial decision. You do that in compliance with specific law, case law, a body of evidence, and it's under the Administrative Procedures Act, which is a Colorado statute that governs this process. When we go through the exceptions process, your normal attorneys that you're used to seeing, Irina and I, as well as some others on that real estate litigation team, are not advising you. You have conflicts counsel or adjudicatory counsel who fills that role. Again, the primary focus of this presentation is this unique role that you have probably performed at least once. Some of you more experienced and longer standing commissioners have done more than once. Next slide, David, please. Now, before we get into the specific role that you perform when you're reviewing an ALJ's initial decision, it's important to understand a little bit more about the administrative hearing process, where the AGs assigned to a specific case actually are prosecuting the case on the commission's behalf. Now, the licensing law for real estate brokers requires any hearing conducted by the commission be handled by an ALJ. And the ALJ is going to review whether or not a respondent or the broker violated the licensing law as you determined, and whether the sanction that you identified is appropriate under the law. During the administrative proceeding, the commission and its prosecutors, us on your behalf, have the burden of proof. We have to establish your disciplinary case that it satisfies specific legal standards of evidence. And in an administrative hearing, all of the rules of evidence and legal formalities are followed. It is a very formal legal proceeding with specific rules of procedure and evidence. And during the hearing, the presiding administrative law judge will make legal rulings, and after the hearing, will issue an initial decision. Now, the initial decision is a formal legal recommendation to the commission based on the hearing. It includes the ALJ's specific findings of fact and law, and it is based on the ALJ's observation of witness testimony, determinations of witness credibility, and other evidence admitted during the hearing. Again, the whole process is governed by the Administrative Procedures Act and a body of case law that has been established over the years interpreting the APA. Now, that recommendation by the ALJ after the hearing has concluded is called the initial decision, the ID. And that is a recommendation that either party can appeal, or as we say in administrative law, take exceptions. So exceptions is a specific term of art used for administrative proceedings that is probably more familiar to you as an appeal. But at this stage, we refer to as exceptions because that's how the law refers to it. Now, during this administrative hearing, when your assigned AAGs are acting as your prosecutors, we're creating a formal record. And that formal record is defined by the Administrative Procedures Act, and the commission is limited to that record if exceptions are taken. Next slide, please. Now, this exceptions process is where the commission splits off from its role as a prosecutor, and all of a sudden it is the adjudicatory role. It dons its judicial robes and becomes the adjudicator. When the ID issues, that is when that split occurs. Now, the prosecuting AGs who prosecuted the case at hearing will stay on behalf of the commission as its prosecutor role. But in your adjudication role, we don't advise you anymore. Your conflicts counsel, someone outside of our office, they're within the AG's office, but they have a separate, they're not even in the same building, and they're completely separate from us in order to ensure due process or fairness for the respondent, and so that you're advised on your review process. Again, this is a very unique feature of agency law, and it's kind of hard to comprehend that the agency, the body that actually decided on what discipline and what violations occurred and prosecuted the case, is now actually sitting in as the adjudicator and deciding whether or not the initial decision by the ALJ is appropriate. And you'll notice that when this is placed on your hearing by the Division of Real Estate or placed on your agenda, it's identified as a hearing matter. So it's very clear to the public that your role is to be here in a hearing matter. And again, we are not here to advise you, although the AAGs who prosecuted the case, if they're taking exceptions on your behalf, will present your position. And that's to avoid any potential conflict that you have conflicts counsel advising you. It's important to note that just by the simple passage of time, it could be 3 years, it could be 5 years from the time the commission first considered this case and elected to take discipline and identify violations. You might not even be on the commission anymore. It could be a completely new commission who is acting in the adjudicatory role. But just for understanding of the process, one of your predecessors had initially looked at the case and made those deciding. So the goal of the exceptions process is a fair assessment of the parties' respective positions based on the record evidence and getting the judge's initial decision to the commission's final agency order. The decision that I just discussed, the decision how it was made, it took a long time. It resulted in, maybe 3 or 4 years ago, the prosecuting AAG filing the notice of charges. Both parties have engaged in discovery, which is evidence gathering. They've had various pretrial arguments. They may have even attempted mediation. Ultimately, though, if there's an initial decision, they went to hearing and they litigated the case in a formal proceeding for a day, a couple days before the ALJ. And that ID is the summary decision of all of those events. And it reflects the efforts by both parties and is a crucial step in getting to a commission's final agency order. And so when you see exceptions pleadings on your agenda in a hearings matter, that's where we are. That's the backdrop for your role as an exceptions review panel. If you could turn to the next slide, please. So when you're preparing for exceptions, when you see that on your public meeting agenda, their role is to read the initial decision. It's to read the materials that are provided to you. The parties will file exceptions. One party might have only filed exceptions, and so one party only responded to them. But it's important because this is a really crucial role. It's getting to your final agency order that maybe you take notes and write down your questions when you review these documents. So you're ready to ask your conflicts counsel about them, because we're not advising you, your conflicts counsel is. And they are key to this process. And again, this is a very formal legal process, and there is a lot of procedures and steps on how to review an initial decision based on whether a party might be taking exceptions to a specific finding of fact or law. And it's important that you get your conflicts counsel's advice on those issues and questions. So just definitely come prepared and ask conflicts counsel for advice on the legal standards that apply to your review. And again, the hearing record is defined by the APA. If you think something is missing or you want more information when you're reading through the exceptions material, that is a question you ask your conflicts counsel before you make a decision. If you can't find something, if you're curious about an issue, you ask your conflicts counsel. And again, your conflicts counsel can go into executive session at the start of your meeting to address those legal questions. And just to reiterate, the commission is one entity with two very different roles. And I know that you're much more comfortable in your role assessing complaints and, making those types of decisions. And you're in unfamiliar terrain when you're acting in your hearings capacity. Next slide, please. And just some little details about what you're looking at in the exceptions public hearing when you're actually deliberating over the ID in public. You're looking at the exceptions that were filed, whether or not the findings of facts were challenged, whether legal conclusions were challenged. Is it just the sanction? There might be oral arguments, there might not be. And, again, your opportunity is to go into executive session with your conflicts counsel to get all your questions about the record asked in advance, and then to deliberate in public session after that. And again, the reason that conflicts counsel is key here is you can't set aside an ALJ's finding of fact unless it meets the standard of legal review. And that is something that you'll probably want legal advice on. The same goes with the legal conclusion. And next slide, please. Now, after you've deliberated in public session on the exceptions, again, your end goal is to get a final agency order, and that might take some time. You'll talk with you'll give directions to your conflicts counsel, who will work with specific staff that DRE has identified that is separate from a lot of their other staff that can help advise on administrative matters to get that final agency order as you discuss during your public meeting, because you will be giving direction to your conflicts counsel on what you want and what you believe after you've reviewed both parties or whoever was taking exceptions. It might take a few days, it could take a few months, depending on the issues involved. Once the FAO is issued, that is the effective date. Again, the hearing the hearing process can be time consuming and take a long time. And you might have decided that this particular licensee, their misconduct warranted revocation, and you might have thought that 5 years ago. But that revocation, if that is what the commission is asking for in the final agency order, won't take effect until the FAO is issued. And there is also an opportunity for the respondent to challenge the FAO. So it's not over with the issuance of the FAO. They can appeal that final agency order directly to the Colorado Court of Appeals. Next slide, please. Now, if it gets to the Court of Appeals, the commission action can be overturned in that tribunal. And these are the legal bases for the appellate court to overturn a commission action. If the court finds that the commission was acting arbitrarily or capriciously, made a decision that was not supported by the record evidence, or made a mistake in interpreting the law, or just overly exceeded its authority. Now, during this process, you are no longer represented by conflicts counsel, but your normal counsel that you're accustomed to assigned to the real estate litigation team would be advising you during the appellate process. There is a presumption of regularity in agency actions. However, that can be rebutted if there is any evidence that the commission acted arbitrarily or capriciously. And the next slide kind of goes through what that looks like. That is a very legal term of art, and there's lots of case law that interprets that. It's basically, if you could turn to the next slide, just because there's a little bit more understanding of the case law. The top 3 squares there basically are cases. They reference case law that says, you know, if the commission neglects or refuses to use a reasonable level of care, if it didn't require procedures, if it denied a hearing or denied due process without valid reasoning, then the court can overturn a final agency order or an agency action, an agency final action. And the green squares kind of highlight, regulation. You have a presumption of regularity. You followed all your procedures. You gave full and impartial consideration of the evidence. Fine, decision upheld. And usually the FAO or the relief that the respondent is seeking would be denied at the appellate level. And that's it. That's my exceptions training for the commission. If you have any questions, again, we can address them after Irina does her standards of conduct training. Thank you for your attention.
Good morning, commissioners. I would like to provide a refresher training on commission standards of conduct. Next slide, please. So I want to start with the overarching question, why? And the question is, why are you serving the public, and general consideration for public service? The paramount to that concept is the concept of public trust. The people of Colorado view commission membership as a trust. The trust that exists because there is a confidence in the honesty and the integrity of the government. That confidence will be destroyed if the public believes that commission acts to advance their membership, the members' personal interest. Commissioners act in the public best interest and must set aside their own self-interest and that of their profession. So to maintain this integrity, commissioners must avoid the risk and appearance of bias, prejudice, or impropriety. Next slide, please. So that brings me to an important concept, the concept of ex parte communication. This term, ex parte communication, most commonly used in judicial setting, but it has a broader application. It is applicable to any communication that excludes parties that had to be included. So as it applies to your role as commissioners, an ex parte communication is an information provided to a commissioner about a pending licensing matter, policy matter, or rulemaking proceedings. And that communication is made outside of formal proceedings and is not made available to the entire commission. Next slide, please. So let's talk about the dangers of ex parte communication. The commission's role can be summarized in two key functions. One is reviewing disciplinary matters and licensing applications. That is what Gina was describing as your prosecutorial role and as your role as a judge during exceptions. That, in my opinion, goes to one side. And there is another side, very important role that you have as someone who promulgates policies and rules. I will discuss the dangers of ex parte communication in both concepts, in both contexts, rather. So in the first instance, where the commission acts as a prosecutor or as a judge, ex parte communication may violate rights of individual and hinder the fairness of the process. Because an individual has a right for decision-making by decision made by neutral, unbiased tribunal. Such decisions must be on the record, meaning on the record of information considered by the entire commission. This concept of the entire commission is very important because you are not acting in your individual capacity as a commissioner, but rather acting as the entire commission, as a whole indivisible body. Next slide, please. So let's talk about the dangers of informal communication between commissioners and industry members. Communication with industry members have traditionally been an important and valuable aspect of rulemaking. When done properly, those communications are a way to engage the industry and the public and obtain improved data, information that can assist the commission in making well-informed decisions. However, ex parte communication can create an appearance of undue influence that may cause the public to lose its trust. If the information is received in an ex parte way and is relied on in making a decision without disclosing it on the record, that is where we are in danger of jeopardizing the integrity of the process. Next slide, please. So, what to do if ex parte communication is received? Simple answer, two-step. Stop and make it part of the record. But let's unpack. When a commissioner has received a private communication at home or at social gathering, the other commissioners have not heard it, cannot debate it, and the affected party, if there is such a party, cannot refute it. If the commissioner does not disclose it and bases any part of the decision on that communication, a violation took place. All communication must be on the record. If a commissioner received an ex parte communication, the commissioner must stop the communication and direct it to the entire commission. When the commissioner has concerns about ex parte communication, it is best to describe the communication in detail to the entire commission. Next slide, please. Ex parte communication during rulemaking or policy considerations. The guidance that I've just provided is equally applicable to the time when you are acting as a rulemaker and considering policies. As you know, rulemaking is a formal process that is guided by the APA, the Administrative Procedures Act. The division manages this process in accordance with the APA. The division actively solicits input from the public and the stakeholders. So having ex parte communication outside of those formal channels is dangerous and is not acceptable. Next slide, please. Yes, another important concept that I want to refresh everyone's recollection is confidentiality. It is important to remember that information received by the commissioners in their official capacity or discussed during the executive sessions is strictly confidential. Dissemination of such information may not only violate legal requirements that certain information be kept confidential, but such disclosure may waive the attorney-client privilege. Most information provided to the commissioners by the division is confidential and should not be disclosed to anyone. Next slide, please. So the commission is a governmental entity, and it is paramount to its proper functioning to comply with all applicable laws. If you will have any questions about ex parte communication, conflicts of interest, ethical requirements, or confidentiality, please don't hesitate to contact your general counsel or the division. So that concludes my refresher training. And at this point, I would like to offer the commissioners to consider whether you would like to go into executive session so you can ask any of your legal questions about Gina's presentation or my presentations. Would it be helpful?
Thank you, Irina and Gina. I don't have any questions personally, but we'll let the rest of the commissioners weigh in.
Thank
Thank you, Gina and Irina. I didn't have any questions either, but I do appreciate the overview.
Thank you for the training. I appreciate both your time. I don't have any questions either.
Thank you. That was very helpful and informative, but I do not have any questions at this time. Thank you.
Okay, so it looks like we do not need to go into executive session. Oh. So next we'll be moving on to policy matters.
So
And-
commissioners, the first item on your agenda for policy matters is the forms global list. We need you to provide direction to us about what forms you want us to work on in 2026.
And I have a question on this. Are we just going to go through every line and how should we handle this? Because I know there's about 80 something.
So I don't think you need to discuss the ones that are outside of the 3-year moratorium
Okay.
timelines. So I would focus on the ones that are slated for 2026 and the ones that have a blank date.
Okay.
So I went through and I kind of looked at, I think, if I'm going back through those that said either new form on there or that were, I believe, going to be slated for 2026. So I have kind of line numbers, as long as they didn't change recently in the last, or maybe week. I've got some that we can potentially focus on.
The line numbers have not changed.
Okay. So I don't know, unless anybody else has a different way of wanting to go through these.
Do you have the form names or just the line numbers?
Yeah, I line 4, it was a new form, agricultural land listing contract was a suggestion that was on there. I didn't think it was necessary. Our land exclusive right to sell accommodated this. But if there were missing provisions that someone needed in there to incorporate for that, I'd be open to that. I just didn't know, there's just not a lot of information on some of these, so I don't know what someone was wanting out of that. But I did want to address that since somebody put that in there and it might be up for review. Did anybody else have that particular form on their list?
Well, I went through every single one of these just in case,
Yeah.
but
I had
but-
originally too, and then narrowed it down based on that last guidance.
Yeah, so on that one, my notes were that I asked a question, what language that currently isn't in the land contract is, is being suggested. I'm not really, same thing that you're saying, I'm not sure exactly what the suggestion is. And I also made a note that could that language be added to a listing contract, but again, there wasn't a whole lot of context on that one as to like what that agricultural land listing contract would entail. And I don't have a lot of experience in agricultural land, so I'm not really certain what they're looking for.
Marcia, when we get these in that suggestion, is that all the information that we get, or is that kind of a overview of what we get? Like,
That is the suggestion that is received.
That is
So
it,
some
okay.
people are more comprehensive than others, and then I will tell you, it is a hodgepodge of what we get. Some people want to know how to remove their wife from the deed. We don't include those on your global list. It's kind of a catch-all that ends up in that suggestion list, but some people are a little more detailed when they're with their suggestions than others.
okay.
So if you really don't have enough to base a decision on, I think it's okay to pass on that one.
Okay. I would remove that suggestion.
Agreed.
Next one was line 5, new form. Let's see here. This was on the title insurance and closing services. I feel like we've completed this in the disclosure of the settlement services cost, both in the exclusive right to buy and in the CBS.
Yeah, my note says Section 8 of CTBS provides, or CBS, provides clear indication that buyer or seller may choose the title provider. So I do feel like I think the concern was people not knowing that they can make those selections. So that's my note on that one.
Yeah.
So my recommendation would be to remove it.
I agree.
Quick question though, on some of these that are 2025,
The ones that are marked 2025, I will go in and update with the new moratorium date, because some of them are like the listing contract, which you just did in 2025. So the new date would be 2028.
okay. Because there were a couple on here. I have to go through as we go through. I'll look, but there were a couple that actually had corrections that needed to be made that weren't made. So would it be more helpful to just give notes on those instead of, because some of these are going to be contracts that aren't up for.
So I can update the date on it, and when it's up for you to consider that contract again, you can consider those suggestions at that time.
Okay. And one example is line 23. I'll just use that, which is 2027 is the date, but there was a correction needed on that one. There's a few of these that have corrections that are needed. Maybe they're typos, things like that. So should we just ignore those for now?
I would. If it's something where it's a typo, like if there's legislation this year that requires us to move the CBS out of order again, we can definitely look at this list and identify the typos.
Okay.
And then we can work the typos in if we have to move the contract to buy and sell out of the rotation due to legislation.
Gotcha. Okay. Thank you. Okay, sorry, Erica. I just had that quick question while I was looking at some of these from 2025.
No, I had the same question, so I think that's good. I don't want to skip anybody else's questions too, so if I pass something, certainly let me know. Line 7 had new form, HOA disclosure form for buyers. I couldn't access the link that was provided on there to review what was there.
Me either.
Yeah.
I have the same note.
So I can kind of give you an idea of what it was. This came out of the 2 task forces that the division had to manage as a result of 2023 legislation. One was a homeowners rights task force. The other one was a Metro District homeowners rights task force. And it was really just kind of a disclosure form to go over kind of everything that a prospective buyer should be aware of, if they're buying into an HOA.
I mean, my initial thought on this is the contract itself, the CBS, goes into pretty good detail about HOAs. Maybe not perfect detail, right? But I mean, it's pretty detailed, which I always felt was sufficient. And it's hard, I guess, not seeing the form to determine if this would be helpful or not, or just one other form, you know? So I'm kind of leaning towards just not doing anything, kind of leaving things as they are. Especially since I just don't have a point of reference.
And if you'd like to defer kind of this particular item to your next meeting, I will track down the form that was in the link originally.
Okay,
I think that's fair.
let's do that.
I'd
Yeah.
like to see it, but I agree with Erica. I mean, we've got a fairly significant disclosure and what is to be provided and outs for the buyer if they found something on the HOAs right now. But if it was also dealing with expanded information on special and metro districts, those can be pretty significant right now too. So I would like to see it.
I think it's worth seeing. And then see if it's something that needs to be looked at further.
The next one I had was line 17, and it was also, I think maybe reiterated in line 28. So let me see what those were. It says new form, new title resolution form. Yeah, okay.
Correct.
So those were duplicate recommendations. And I don't have a problem with that necessarily. On the my initial thought as far as having a resolution for that, but I was curious what everybody else's thoughts were to that.
And my initial thought was, I didn't know that it was super necessary, right? I mean, the termination form allows for termination. I mean, I don't know. Whenever I've had title issues, I don't know. I just have emailed, you know, parties, and that seemed significant. That seemed appropriate, but I guess I would be open.
Yeah, because if you need to actually have come to terms with a resolution on it, it could be beneficial. You know, you're kind of going back and forth with what can the seller do to bring that to an agreement. It might not be something that they can actually do, and you need to come up with something. And a lot of times the seller doesn't know that they've got an issue until they've pulled it forward.
Yeah.
And so that resolution is a document that everybody can work towards, kind of like that inspection resolution, which I think is really important. And if you can't come to a resolution by a certain amount of time, it lets everybody know without, I don't know, I feel like it could be a really beneficial document.
Well, and I do agree with that. The other thing I'm thinking about is there's no objection form. So it's kind of like we have a resolution form, but no objection form. So that's why I was thinking it's kind of to me unnecessary. But it, you know, it could be something. I mean, I would say title issues, they definitely happen. Not as obviously as frequently as we're using an inspection. So the question is, are they frequent enough that we would need to, because to me, if you're going to do resolution, you need the objection form. So are the issues frequent enough to warrant 2 new forms? Because I just don't think you could do the resolution without the objection. An official form, you know? So things to
makes
think
sense.
about.
I mean, I just had an issue with one that I could have used an inspection resolution for. So I think how often, like it's been a while since I needed it before then, but I remember thinking, boy, I'd really like to have this instead of having to go back and forth. And then I had so many amendments to try to get it to where we needed to be, and that was not ideal.
Right, right.
So it'd be a much smoother path where everybody knows what they're dealing with.
Do you agree, though, to have resolution, you need to have a formal objection?
Well,
Just like it would be,
I think
it would be mimicking like the inspection dates. So inspection objection, inspection resolution, right?
but you have the dates, so
So to me, it's like, okay, if there is something on title, you need a formal, if we're going to add a form, then you need a formal way to object to that issue.
yep.
And then you need the formal way to resolve it. Again, I don't know. I'm curious to
pull this
know
up
to see what everyone feels in terms of frequency of this. I can count how many times, and it's probably over. I mean, it's not. I mean, in the last 22 years, it's probably been over 10, but we're not talking. I mean, we're talking about a lot of transactions. You know what I mean? And it's not like every other transaction is having major title issues, but they can happen, and I've definitely had my share of them.
Mhm.
I've just been able to manage it with the processes we had, which is just, kind of emails and putting it in writing and things like that. But I mean, I think it's worth having a discussion. Does anyone else feel a certain way about this?
So is that something that you want the division to look into as far as a form or not?
I would be interested in the division's thought and opinion on it. But I mean, do we think that a forum is beneficial?
Are we
Yes.
seeing complaints on, that are coming in? I mean, I don't think we've seen too many come up on the last,
I don't think this is a leading complaint generator for us.
yeah.
I would leave it if it's not a leading complaint generator. Why add more to the contracts? I would leave it.
Sorry if I can just interject for a second. We do have a title related objection notice already in our standard forms. But I don't see a corresponding,
Resolution.
yeah.
That's what I was trying to find. I'm just like, gosh, it's so rare that we use those. So if we have an objection form, it would make sense to have the resolution form.
Agreed. So where's sorry, I'm going back because I just don't.
Would you guys like to look at that? Maybe I can send it. I don't know if I can send it
Yeah.
to David and David can share it maybe.
Yeah, I'm pulling it up now though. So it's it's a notice. Okay, here we go.
Yep.
David, are you sharing
I'm still trying to get it to
it to us?
Clearly this doesn't happen often because
No, it's infrequent.
yeah, because I haven't even used this form. Well, since there is an objection, then it would make sense. That was just my thing. If we don't have an objection, like we need an objection to go with the resolution. But if we have an objection and no resolution, then that also
Goes hand in hand.
yeah. So I guess
Thank you so much.
yeah, that was very helpful. I
There we go.
really appreciate that. So then I would say I'm in agreement with you, Erica, that yeah, we should just go ahead and consider adding that form.
Okay.
I think one of the past concerns, though, is you, as a broker, identifying how to resolve a title issue may kind of put you in the danger zone of unauthorized practice of law.
Yes.
Yeah. That's not the expertise here, so.
I'm just trying to play out situations in my head that I've experienced.
And I think you have to weigh that at the time you're doing this, and if you're bringing in your counsel at that point as well. But there are title issues that can be fairly easily dealt with, and the resolution form would be incredibly helpful.
Mm-hmm. Yeah.
Because otherwise we're getting pushed into amendments to deal with this, which is not ideal.
And I think commonly what I've seen, you know, there's maybe liens on the property that really shouldn't be there.
Certificates of non-compliance, you have to push dates out because of probate issues.
mhm.
So those are
Definitely probate stuff.
yeah,
I'm
the
trying to
variety
think.
kind of come to mind.
And resolving those, I mean, you know, the title company is instrumental. Are we just, so I guess the question is, if we are given instruction on how to resolve it from title, and then we put that information on a resolution, is it still practicing in an area where we are not experts in, right? I guess that would be the question. Does that open us up for litigation concerns if we're acting on what, you know, that third party, whether most often for the simple things, it's just the title company, probably other cases, the attorneys are involved. So I don't know.
Well, we do have the opportunity of, I mean, we can utilize the AGs and also reach out to COBAR and the title association to kind of get feedback if you want to move forward with some sort of resolution document. But I think we have to put tight guide rails in so that brokers are not practicing law without a license.
Yeah.
Absolutely.
Can we do that? Is everyone in agreement that that might be a good way forward on that one?
Yeah, we'll take a look at it.
Okay.
Okay, so we're adding the title resolution form to the list of documents to look at.
Yes.
Okay. All right, did anyone have any other documents?
Line 31, just the lead-based paint said that we've got some revisions needed to that one.
Yeah, I had a question on that one too. My question was, what are the revised rules that was being referenced here? Do we know?
We don't know. I think we'd have to do some research.
Okay. Because I'm not unaware as well.
Okay, so why don't we add that to the list to look into?
Okay.
The next one was line 37, a new form. Buyer change form. And my note just said likely unnecessary, easily completed with an amendment. But
Yeah, my notes mimic yours that, you know, no change recommended unless I just had a note unless, you know, attorneys see this as a real issue. But
as Erica said, we can easily do this with an amendment, so we probably don't need the form.
Yeah.
okay.
Like I said, you know, there are some, if attorneys are experiencing you know, seeing issues because of this, maybe, but I don't, from my perspective, I don't think it was needed.
Okay, the next one I had was line 39, and that was the broker disclosure to buyer. Definitions of working relationships. And this is the recommends changing the title on page 3 to buyer broker's compensation disclosure. No, that's an agreement to pay that buyer's broker if it ends up closing. That'd be problematic.
And it says right now, it says, oh, let me have to pull it back up. It says, it does reference compensation agreement
Yeah, I think that's what it is. It's agreement.
versus disclosure. My notes just said no change recommended because there are instances, now obviously the ideal scenario is to have an agency agreement, right? Whether you're broker, agency or transaction. But if that's not in place, technically, an agent can still close a deal. So it would still be, in my mind, an agreement.
That was what I thought as well. I thought if we change that to a disclosure, I just think that would be problematic. I would not recommend making that change.
Yeah. Well, you and I had the same note, no change. Anyone else disagree with that? Okay, so we'll.
Next one was line 40, new form. Let's see here. It says that was a form needed to show contract was presented to seller when there is no counter proposal sent back, showing the listing agent even presented the offer. I was very curious what everybody thought about that. We used to have something along those lines a long time ago.
That's funny. My note says, should we I noted no new form, and then I noted, should we bring the rejected box back?
Yeah, my biggest concern on that is I know there were just a lot of accidental acceptances, and I just don't want to bring that portion of it back where we're having them initial electronically and accidentally accepting something that they didn't want to do. But I do understand the request, where
Yeah.
people just are not certain that their offers are getting presented. And so I think I want to express the validity of that request. But I don't know, a whole form, I don't know.
Yeah, I totally 100% agree with you. I think a form is probably too much. However, I also understand the concern in making sure that offers are being presented to sellers, all offers, right? And I'm sure lots of agents, including myself, have experienced scenarios where you're not certain that your offer was presented. So I get it. I don't know how helpful. I did mention the checkbox, but then is that all that helpful? Because I guess that doesn't give validity that offer was actually, sent over. I don't know. I mean, my thought process, my initial thought, I just think a new form was just a lot. But I also think that in fairness, if a broker wants to ensure that their offer was presented, that they can ask for some sort of proof of that to that agent, But I just don't know if we deal with this in contracts. Any other thoughts or opinions on that one?
I don't think we need another form.
Yeah.
I don't present any since I'm not an agent. So I kind of defer to some of the forms as far as like some of the stuff that's already in the contracts to listening to what you all say and then making a decision thinking because you have the everyday experience with it. With what you're presenting and what you see in each individual, and then all we see is what actually makes it to the commission, right? So I'm listening to what some of you say because I don't see all of the I don't have all the everyday experiences that you all do presenting contracts.
Yeah, I liked the days where we had, there was a time where we did have a couple of boxes, but apparently they caused a lot of confusion. But I liked when we had, it was like a rejection box or something, or initial. It's been so long ago, I'm trying to remember how it was, but I know there was like a rejected or something on there. And then there was a time where we had the counter proposal, because I think I still think that that's a little confusing with our contracts. And so I liked it being there, but the feedback that we received is that it was confusing and people were signing in the wrong area. And,
And-
from that
and so-
perspective, I don't know that we do anything if it's going to cause more confusion than help.
So that was basically the buyer's agent is presenting a contract to the seller,
Mhm.
and the buyer's agent doesn't really know if their offer was actually presented, and maybe they got 10 offers,
Mhm.
and you don't know if yours was really even looked at because they just kind of glanced at them and they were like, okay, these ones look the best, and I'm not even
Mhm.
going to look at these other ones.
It
So
could be
without looking
that.
at it.
It could be that the offer was in a broker's opinion unreasonably low, right? And they didn't show it. Or it could be that it was a backup offer. There's so many, ways offers can come in, and there's an uncertainty if it was really presented, right? And the brokers have a duty to present all offers. So I understand the need. It's just finding a solution as to, I do think a form is way too much, but just finding a solution to, I guess,
When was that checkbox removed?
oh, years ago.
Years
Yeah.
ago,
Been a
I don't
while now.
remember.
And do we know
Probably
why it
10
was
years.
removed? Do we know
because there was
why?
too much confusion. People were
Yeah.
checking it
The
and
confusion,
signing
okay.
things. It was creating issues.
Commissioners, I would also recommend contemplating how many consumers would actually want to sign an additional form as well, like how many sellers are going to want to sign something.
Yeah. I mean,
Yeah.
I
So
think we're all in agreement, no new form.
So no new form. Okay.
All right, we'll move on. Well, the next one I have is line 54. Am I skipping any that anybody else want to jump in there before line 54?
Think so. Let me just double check real quick on my notes. No. Okay, 54.
So let's see, I have an update paragraph reference numbers as the paragraphs in the CBS have changed. So yes, we would just want to do that.
Yeah, I had that as a definite yes.
Okay. So Marcia, that's something you guys can correct then?
Yes. And what I'll do after we get done going through the global list is I will give you a summary of what you want to reject and what you want to move forward so that the commission can take a full vote. Does that work?
Okay. Oh, that'd be great. The next one I have is line 57, and this was the brokerage disclosure forms. And so that's the informed consent language is still in BD 24 and the definitions of working relationships. And so that just needs to be updated.
Okay, yep. Oh, I can't highlight that. Oh, there we go. So yeah, agreed, that it should be removed.
Next one I have is line 60. This is a new form contract to purchase water. And I mean, I agree, it's gonna be very complex, but I would hesitate to separate it out from the purchase contract. I mean, if there's a more robust way of addressing it, I would prefer that method, but I don't see any specific suggestions.
Yeah, I think when we get into water, that is beyond most agents' expertise for sure. And at that point, you need, in my opinion, you really need to have attorneys involved.
Yep.
When we start to really get into water rights and things like that. And especially when we're talking about purchasing water rights. So I don't think we should get in the weeds on that one. I think, if anything, we should send a message that brokers should be advising their clients to seek legal advice, professional legal advice on that one, and then just kind of leave it in the contract. And then, the attorneys involved can do whatever is necessary, but I don't think we should create a new contract or form.
100% agree. Okay. The next one, line 69, promissory notes. And
This took me back.
yeah,
I was like, promissory notes. Oh my gosh, I forgot about those.
maybe that's coming up again. I don't know, but
What line was that? I'm sorry.
Valid, very valid that needs to be updated for sure if we've
Yeah.
got not matching. So
What line was that, Erica? I'm
that
sorry.
is 69.
69. Okay.
And so they've got to be consistent. I recommend updating those.
Yeah, I just wrote that I don't have any issue with the change request. So yeah, I think we should approve that.
Okay. Line 71 says new form for informed consent.
Well, we know that's probably not gonna go. So my note is just we've discussed that many times, and that attorneys can provide that. And they are. I've already seen it happening, so I would say no. Of course, I was advocating for that, but we don't have that rule, so kind of just changed everything from my perspective in that regard. If we had a rule, form. No rule, no form. That's just my opinion. And since there's no rule, I think brokerages should just seek forms from outside sources like their attorneys. Any other thoughts?
Sounds good. So the next new form is on line 74. Cigarette smoke disclosure.
Yeah, I mean, I see the practicality for having this form before you show it. But I'm kind of like, you maybe talk with your MLSs about adding a smoke-free field. I don't know, but as far as the disclosure, it's on the SPD under the environmental section. So I don't believe a separate disclosure would expedite necessarily the timing of the knowledge.
Agreed. And my notes kind of mimic what you just said. I just put it would be a great recommendation for the MLSs, and disclosures already are in place. So I think that we remove that one.
I didn't have any others on my notes.
Let me just make sure. There were outside, which I can do that separately. There, like I said, I did note some typos and things that were pointed out. So I think if we haven't, so this is a running list, Marcia?
That's correct.
Okay. So I do think, if we have a opportunity to go back and make some of those typo changes. Like I saw one, it wasn't even mentioned, but it was like a double paragraph. A double parenthesis on the end of a paragraph, and so there's some things, some little small things. All right.
You ready to for me to give you a recap on what you decided?
Yes.
Yes, thank you.
Okay, so the ag listing contract, the title insurance and settlement services form, hold on. Number 37, which is the buyer change form, and the contract to purchase water a new informed consent form, and the cigarette disclosure form. Those are all items that you want removed, and you're not going to move forward with those. You're going to defer the HOA disclosure form until the April meeting so that I can find the proposed form for you. And then you want us to move forward on the title resolution form, the lead-based paint disclosure, the short sale addendum, the BD 24 and the working relationships, and the promissory notes.
Yes.
Yes.
Sounded right. Yep.
Okay, so can you take a formal vote, please?
Okay, someone would like to make a motion?
A motion to approve Marcia's list.
I know, I didn't know how to say it either.
Do we have a second?
Second.
I'll second.
All right, any further discussion? All right, all those in favor?
Aye.
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 Any opposed? Okay, motion passes.
So commissioners, the next item on your policy matters is B, commission position 22, conflicts of interest.
Okay, I can jump out there on this one. And I wasn't sure if we should be doing 31 first and then 22, or I mean, I can do 22, but
You can definitely take them out of order.
can we do that then? All right, let's do 31 first.
Okay. Sorry, it took me a minute to pull it up again, but I had it.
Yeah, I just have to get my, so, on 31, since we did not approve, the rule, we just need to repeal this. And so that's where I'm headed with this one, unless anybody has any other discussion on this.
My notes were, it's more of a guide. Correct me if I'm wrong. This is my interpretation. That it's a guide, but it does reference rule 6.27, which doesn't exist. So minimally that language needs to come out. And I guess the question is, do we want to give a guide or no on how to deal with conflicts of interest? Certainly we have to remove the 6.27 reference minimally.
Well, CP 22 is your conflicts of interest, and that's why I'm like, which order do we go in on these then? So if we repeal CP 31, we could go back to CP 22 and have that edited for kind of what we're dealing with now and just kind of update it a bit. But then it's not referencing everything that's in CP 31, which was very much dealing with the rule.
Yeah. Hang on, I'm just reading my notes on 22.
Because I like the bulk of 22. But the changes begin in, on page 2 from the previous one. And so we need to edit that for the references for CP 31. And so it just kind of needs to be polished.
So Erica, are you wanting to make a motion about CP 31?
I can do that. I motion to repeal CP 31.
And let's get some clarity real quick. So you're motioning to repeal CP 31. However, were you saying that we should add something to 22? You mentioned.
Well, then I would go back and deal with 22. That's why I wanted to do it in a different order.
Okay. But dealing with 22, there's going to be added language.
Potentially. Well, I don't have any language specifically, so I'll tell you that now.
Okay. Because maybe we could have discussion before we.
Well, and if we get a second, we
Motion,
can go into
'cause I don't-
discussion, but
Yeah, but, okay, do we have sorry, I know I went out of order a little bit, but,
Okay, so Erica made a motion. Did you want to have more discussion?
yeah, I'll second so we can have a little bit more discussion about it. So second.
Okay. And what discussion are you wanting?
Back to the 22, what changes would we make to that in order to if we repeal 31? They're kind of they go together. I think we have to discuss them together.
I don't have a suggestion on language for CP22 yet. It was just dealing with conflicts of interest. Whereas CP31 is dealing with confidential client information by an employing broker specifically. So this is why, CP31 was dealing with the rule that we did not pass. It should not be in place. It shouldn't be referenced. It just needs to be gone. And the reason we should do this in order is because CP22, the current one, references CP31. So in order to keep CP22, we need to do some cleanup on that to just bring it up to date, making sure that it's not referencing a rule that is not in place. And so I think that that's where I would head, but I don't have a suggestion. I think that we give it to staff. They can clean it up and bring it back to us.
So commissioners, just to flag for you, just because you didn't adopt 6.27 doesn't mean the informed consent requirement doesn't still exist.
Sure.
Along with designated brokerage. So confidentiality still doesn't extend up to the employing broker.
And I'm just reviewing 22 again, which is why I'm silent. I mean, my initial thought process, and we can just, kind of poll our commissioners and just figure out, just decide which way to go. My initial thought process, again, was as a guide, because it's a position, not a rule. As a guide, I thought it would be helpful to have at least some version of 31. Particularly when, my concern is because the position hasn't really changed in terms of how informed consent is viewed. It would be nice to give the industry some sort of guide as to how, the commission and the division feels about that. So that's why I liked having something there. But also, I understand your perspective as well, Erica. So I don't know if maybe the other commissioners can weigh in on this and let's see where we are.
I mean, Erica, I liked your idea. I think that it is a position statement, and just scrubbing it and cleaning it up to eliminate the rules that we've eliminated that are no longer in existence. I think that's probably step one.
I agree with that. Eliminating the 31 and then cleaning the 22.
Is that what you were saying though, Autumn? I don't think
Yeah.
that's what you were, is that what you meant?
Yeah, that is what I meant, like
Okay.
just scrubbing it, cleaning it up with all the modifications from the last commission meeting and having it reflect where we are today.
Are you, just for clarification, are you saying we keep 31 or we repeal 31?
Oh, I apologize. I was on 22, so I wasn't talking
Okay.
about 31 yet.
Sorry. And we're kind of talking about
know
them
we're
in
going back and
conjunction.
forth.
But yeah, so really what the motion is to remove 31. And so we're just kind of discussing whether or not everyone wants to remove position 31. My thought was keep it, or maybe make a few changes. Obviously we need to make a few changes, but keep it as a guide so the industry has some idea of how the commission and the division feels about that. Whereas Erica says, let's just get rid of it and then kind of work on 22. So just want to get a feel for what everyone's position on
I mean,
that.
do we feel like 31 provides? I don't recall who said this. Maybe it was somebody else, but I mean, just because we take this away doesn't mean that the need is no longer in existence. Like, I think having some kind of position showing and giving some detail of what our expectations are and what the rule of law is, will actually be more helpful in keeping people out of trouble in the future.
Yeah.
That was kind of the purpose of the rule, was to explain to the industry what the standards were to
Yeah,
achieve informed consent. And so you didn't adopt it, and the division knows what the requirements are, and you know what the requirements are, but the greater community of licensees doesn't have anything in writing that explains it to them.
mhm.
Yeah.
Renee, what were your thoughts?
At the last meeting, I thought we were going to modify some of the verbiage in here. You had written up some stuff and I thought we had looked at some different verbiage, but we never got that information. Or I never saw it as to what other verbiage. I mean, majority of this is just repeating what's already in statute.
And I know we had verbiage that was presented, but that was more for the rule, which did not happen. I don't know that we made any changes to the position statement.
There was no proposed modification language presented at the commission meeting in December.
I mean, really a lot of this, to your point, is in statute. It's just the page, let's see. How can I identify? On our end, it's page 2. The paragraph after transaction broker. This is kind of where it's all new. Like, this is where the guidance happens.
So commissioners, what we could do is put the language that was in rule 6.27 into this position statement to explain kind of the threshold they need to meet in order to get informed consent. Particularly, I mean, second sentence is Commission Rule 6.27 sets forth the requirements for informed consent. We could insert that into your position statement so that it's at least written somewhere so that the licensees know what they need to do in order to comply with the law.
I think we would need to look at that again before just saying yes. We would need to look at that verbiage, because if we didn't approve 6.27, I don't know if we want all that verbiage in there, so we need to look at that.
And I'm sorry, I'm just rereading all the section that isn't addressed in statute specifically, like the guidance piece. I mean, I don't know. I think it gives enough guidance to know, hey, this is when you're in these situations, this is kind of almost like a red flag. Hey, there's a conflict. To me, it gives the inkling that someone should do something. Like, okay, we have a conflict. We need to get something in writing. I think it explains that it doesn't go into great detail, but it gives a little bit of guidance where if it's gone, there's like no guidance on it.
So, and I have a question just based off of that. As a public member, like if an employing broker does come into a situation where they're reading this position paper and have questions, I mean, of course, they can reach out to somebody at the commission or.
We don't give them legal advice. They need to
Okay.
contact their well, if they're the employing broker, they should probably get legal advice from their counsel.
Gotcha. So we don't have like a frequently asked questions section or.
So this has been one of the challenges with this division, I will tell you, because if you call Division of Professions and Occupations, who regulates doctors, you can't call them as a doctor in the middle of surgery and ask them how to like stop a brain bleed.
Yeah.
They should know how to practice. So if they have questions about the law and how to practice, they need to either go to an educator, their employing broker, and if they're an employing broker, they should be seeking guidance from their legal counsel. The division cannot give practice guidance or legal advice.
Just position statements
The
about
position
expectations.
statements are you giving them some guidance from the commission standpoint.
Okay. I mean, I feel like we've beaten this horse almost to death at this point. So, I mean, I'm kind of at the will of deferring to the expertise of my fellow commissioners being a public member, but I don't know. Erica Sanders, I agree with what you just said.
We do have to give them some sort of guidance. That is true. Because then otherwise, I mean, either way, then even if they go to their counsel, their legal counsel, it's up to their interpretation to it. So at least if we give them something, I don't know. Yeah.
So
That's my thought.
if we leave this in here, then we're back to you've got to get informed consent in writing.
Well, but that hasn't gone away.
Well, but that's what this whole thing is about.
Yeah, but it's still the case. Like whether this is here or this is not here, the way that the statute has been and is being interpreted is informed consent has to be in writing, right? So
that was what the rule said. I think they would be better served getting it in writing to prove that they actually met the criteria necessary, that the consumer was apprised of the risks, the alternatives. It's better to have something in writing to cover your end should the consumer come back to us and say, they never asked me, there was no disclosure provided, they just used my confidential information without my permission.
So if there's no rule in place, I mean, no position statement in place, then, and we kept just 22, does that change anything? I mean, still, is the requirement still in writing or no? Because my understanding is that the requirement was in writing based on, I guess the statute just says informed, which we have deemed informed meant in writing, but I guess it doesn't explicitly say that.
purpose of the rule was to really lay out the criteria for the industry so that they understood what thresholds had to be met in order to obtain that type of grant from the client to share the confidential information. You didn't pass the rule, so I don't necessarily think that you have to say, you can say that it has to be in writing, but it would be in their best interest to get it in writing because it's not uncommon that we get complaints alleging that a broker did something and there's no support in writing to show that the broker didn't do what they were accused of.
So my next question would be, can that position be added to 22? Something that just states the recommendation is to put it in writing and then get rid of 31.
So 22 specifically deals with conflicts of interest. Would you like us to draft a CP 31 that deals specifically with informed consent?
On well, the only thing on 22, 7 and 8 deal specifically with confidential information. Is could we not put it there? Or I mean,
you definitely could expand it to go beyond conflicts of interest. You could do conflicts of interest and confidential information.
is that kind of what you had in mind, Erica?
Sorry, I was just reading that again, the 7 and 8. And don't we already have a section dealing with uninformed consent in sorry, I have a lot of notes.
Not completely on 22. I think if we think the best way to obtain that consent is in writing, we probably would want to just say that maybe at the end here, either because there's 7 and 8 on CP 22 addresses the conflict of interest with the employing broker supervising, as well as employing broker being part of the transaction. And then below that, it talks about error. The firm should err on the side of caution and disclose perceived conflicts of interest. Consumers don't fully understand brokerage relationships. And it gives some
I'm
examples.
confused. Does the statute say it has to be written?
No, the statute says you have to have their informed consent. The in writing portion was proposed in the rule, and that has a kind of cover your own end aspect to it. Although I will tell you, anytime I've been given informed consent, it's been in writing. And I think that was an aspect that the Attorney General's office evaluated when they were giving you legal advice on this issue.
Yeah, that's the only thing. It's like, how do you give informed consent without it being in writing? I don't know. Well, hopefully we don't have to belabor this too long again, but I mean, I don't think it's a bad idea to give a little guidance. I don't think it's a bad idea to mention that putting this in writing is probably a good idea. Whether we do that in CP 31 or whether we just add that to CP 22, I think it's fine and acceptable. I just think we need to go a little further on 22 if we get rid of 31 to mention what the expectation is. And if we keep 31, we probably need to scale it down just a little bit, but definitely can't reference a rule that doesn't even exist. So I don't know. That's all I have. We got to make a decision. So the motion on the table is to repeal CP 31. There's a second. Should we just vote? Or do you want to continue a discussion?
I think if we vote without having any clear outcome, it's gonna leave some ambiguity.
Well, I
Okay.
think we can get rid of 31 and address Erica's concern in 22.
That sounds good to me if that works for everybody else.
Renee and Bernadette?
What are you moving from 31 to 22?
We would be, let me see, let me go back to 31. I mean, I think it has to be prepared for us to review, but essentially page 2, something along these lines. So if you go to page 2, right there, where it's, yep, kind of that area, obviously not mentioning 6.27, but that area down is really where the guidance is. The other part of the CP 31 rule is just referencing statutes that are already there. So I was just thinking we
Okay.
could just
But
add
this-
that guidance.
Okay, but this guidance says you're obtaining informed written consent. And what you referenced previously was that you were recommending it be written. So we have two different things. Are we saying it has to be written, or are you saying you recommend it be written? We have two different things going on.
I think we recommend it be written.
So the other thing is, if you're recommending it be written, and we have this issue come up before the commission, and it's not written, we have a he said, she said. Just thinking down the road, what issues is that going to cause?
Well, and I think that was the whole point of this whole discussion in the first place, and the rules and all of that. The reality at that point, whoever is sitting on the commission, along with whoever is serving as attorney generals, are going to make the determination as to whether or not they violated law. That's it. It's going to be at that interpretation, since we didn't have a specific rule to provide guardrails or anything. So at the end of the day, it's how it's going to be interpreted by whoever is sitting. That's how I see it. But I think since there is an expectation that this be in writing, we need to tell the industry that.
Okay, so we're getting, motion is to get rid of 31 and then to move some of this verbiage into 22. So
Well, the motion was still to repeal, repeal 31, but then we have to add a motion, we have to amend that motion.
Okay, so is that
Marcia, is that a possibility? Can we move this stuff to 22? Just that part, that section that I mentioned?
So it would be kind of cleaner for us to understand what you want to do. If you want to repeal 31, go ahead and repeal 31, and then we can discuss what you want to add to CP 22.
Okay.
Mm.
Okay, so the motion was to repeal 31. I guess we could vote.
okay? All those in favor?
I
I
Any opposed? Okay, motion passes. Okay, so what are you wanting to change in 22?
add a version of the language that states, that we recommend informed consent in writing.
Okay, because right now the verbiage says it may be shared if you obtain written consent. So you want to copy that basically, but change it to that it's recommended.
Well, I mean, that's a discussion. I think we can say that since we yeah, I don't know. I think that might be a cleaner way to do it. We could say that it's required, but I don't know that we were all in agreement on that. So we could just say recommend it.
I don't think there's anything wrong with recommending that it's in writing. It's not requiring it, but it's just giving them guidance that, hey, we recommend you put it in writing. And you could put it down at like number 3. Sorry, not that number 3. I've got 22 in front of me, so just very clean and simple. But I think on 22, they're going to have to go back, like all of page 1 is fine down through number 6. They're going to have to take a look and either remove or clean up number 7 and 8. And then it goes down to the final paragraph, which was similar to the previous 22, which is fine, and just add a number 3 discussing we recommend informed consent is in writing. So I say we don't necessarily have to do a lot more work on it today. We just let staff kind of go back and take a look at that and send us a revision to start looking at.
Okay, Marcia, is that something that you can have staff do?
Well, I would be the staff. So you want 7 and 8 revised and add a number 3 about the recommendation that informed consent be in writing, correct?
You cut out on the first part of that, but
So you want us to revise 7 and 8
yeah,
to make it align with the fact that there's no CP31 and also whatever changes you didn't adopt to Rule 6.17.
correct.
And then add number 3 at the bottom with the informed consent. Informed consent should be obtained in writing.
Yeah, just to give a little bit of guidance on that part.
Okay.
That
A recommendation, but
recommendation is written, informed consent.
I don't know. What does everybody think about that?
I think that's good.
Yeah, I mean, none of these are perfect solutions, right? But I think at the end of the day, we got to provide a little bit of guidance to as much guidance as we can to the industry, and so this gives some insight as to how this will be looked at and considered. So I think it's the best we could do right now. So I guess I can make a motion. Motion to, oh gosh, hold on. Let me think about this. Motion to adopt CP22 with the recommended.
No, we're not
Okay.
adopting it yet. We're having division
Amending.
work on the,
7 and 8.
and
You can
adding another paragraph, 3.
You can make a motion to have us revise the position statement as directed and bring it back to you in April for consideration.
Okay. Motion to have CP22 revised based on recommendations presented today and have division staff present in April.
Okay, is there a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
So commissioners, the next thing on your agenda is an enterprise bank issue, and I believe the AG's office would like to give you some legal advice about this particular issue.
That is correct, Madam Chair. If you can please start the executive session.
Okay, this is Commissioner Chair Renee Lyon. This is a Colorado Real Estate Commission meeting being conducted on February 3rd, 2026. The time is now 10:46 a.m. I move commission enter into executive session pursuant to Colorado Revised Statute, Section 24-6-402-3A2, or to discuss confidential information pursuant to CRS 24-6-402-3A3. The purpose of this executive session is to confer with counsel to receive legal advice on specific legal questions regarding the following meeting agenda items: policy matter E, enterprise bank policy issue. Is there a second?
Second.
Okay, all those in favor?
Aye.
Any opposed? Okay, so there are 5 votes in favor of executive session. We will now enter into executive session. Make sure you turn off your mics and your video here. Okay, I just want to make a quick adjustment. When we went into executive session, I read it as policy matter E. It actually should be policy matter D. Just wanted to make that correction. And I'm going to open it up for discussion as to allowing banks to do business in Colorado as far as trust accounts that do not have a physical branch in the state.
So we're requiring property management, I guess, to put funds into this either trust or escrow account. And I'm thinking how often the person whose money is in there would need to be able to access it, or how quickly or often that property management company needs to access those funds. And I guess if they're waiting to the last minute and they're trying to get somebody's security deposit back or get something back and they're wanting to issue something like that or deposit, or, I mean,
So the
I
issue
would
with
think that,
property management would be more with when you're refunding a tenant's security deposit or giving them a refund of any kind, if there's not a branch in the state where they can go to actually draw that money on the account, they're going to be doing it with an out-of-state check, which does cause issues with multiple banks in the state. As far as now you're trying to get money, but it's an out-of-state bank, it's not a local bank. There are issues there.
because we might hold it. I come from banking, so I mean,
Right.
there's those holds if those people need that money.
Yeah, so
You
that
can't
would
go
be,
cash it, you can't, that would be I would think that's an issue.
and then we
And
also have the issue if we need to subpoena these banks for records, which often happens when we're doing audits with the division. There are issues getting compliance with those subpoenas if the bank is out of state, whereas if the bank is in state, we can follow up on those subpoenas and get cooperation. So I think it is extremely important to make sure that there is a physical bank branch where people can go in and open accounts, do deposits, cash checks, not just an office for either management or loans or some other service, but there actually needs to be a physical branch in the state. I think we need to make that clarification to prevent future issues.
well, I know there's the argument people will always say people are moving to online banking. I beg to differ. I'm not saying that they don't do online banking and apps and all of that, but we still have people that walk into a branch and do transactions. And I think that's really important to have that. And if you're going into a branch that they can only do loan applications, I think that's what this said, is that, they do, it's a office where somebody can go in and do a loan applications. That's not the same thing as being able to do a transaction. Years ago when I was on the mortgage, there was no way I could do a transaction. I didn't do transactions. So I feel like being able to accept money or refund money, anything like that, is really important. It's a disservice to those that do want to access it. So I would think having a physical branch where transactions can be made, where money in, money out is necessary.
I guess my thought on this whole scenario, and I will lean to Renee and Bernadette, as Renee does property management and Bernadette, you have the banking experience. My initial thought definitely was that we are moving into an era where there's a lot of electronic banking that does happen. My question to you all, and then I have a comment, but my question first would be, how many people are still transacting with checks? I don't see it often on my side. I mean, of course, my experience with communicating checks to buyers would be earnest money and then closing funds. And almost all of them always say, well, they just mention they don't have checks. So I'm just wondering how much are we transacting with physical checks?
There's still
I
quite a
feel,
bit going on with physical checks, with
yeah.
tenants paying rent and deposit. All our security deposits are going back with physical checks. All of our vendors are getting paid with physical checks. We're, there's still lots of checks going round and round and round. So it is important.
Okay.
I feel like not everybody is not everybody is this young person that's does cashless or that does, transactions with, Zelle and all these other things. We do have a older membership, and that's what they do. That's what they're comfortable with.
Mhm.
I mean, I literally was just with somebody who went to the grocery store to pay for their groceries with a check. It's doesn't happen very often, but it does, and I think don't exclude some of our, I guess, older community. That's what they do. They don't like electronic. There's a lot of people that aren't electronic. They don't do apps are hard. Moving money like that is not what they do. And so there's still people that do checks. Um, I have 3 accounts and I have checking accounts. I have literal physical checks for all 3 accounts. So myself. So I don't know. I still think people write them.
And then my other comment or concern really would be, and you all can correct me if I'm wrong, I have found that there's a limited number of banks that provide true fiduciary accounts in Colorado. So I think having more options is definitely beneficial, particularly, I mean, from a competitive advantage, right? For cost, and all of those things for consumers, for sure, for brokerages. I mean, I think having more options is definitely a good thing. And I think having more options would still allow those individuals that are more electronic savvy, that's how they like to conduct business, to have an option versus you still have your options. And I won't say any banks, but there's a few banks, they have their physical locations, but I think it gives brokerages options on how they want to conduct business. I think that there absolutely has to be, which sounds like it's statute anyway, there has to be a physical either production branch or banking branch, right, in Colorado, so that would allow us to subpoena and have enforcement in that regard. But I guess, I'm thinking of one bank in particular that I won't mention that has a lot of members that don't have a physical location. They cater to like veterans, right? And so how does that affect all,
Well, we're talking about banks that have the true fiduciary, and
yes.
the division does have a long list of banks in the state that offer true fiduciary accounts. So it's not like there's only a couple, it is a long list. So there are plenty of options and plenty of experts that offer the correct type of banking in this state. I don't think needing another option is a concern because we have quite a list of them here. So I don't think that is a concern.
And you may be right. I just know in my experience, I've personally had trouble, which I was not aware that the division had a list, because that's just not the area. I don't operate in a manner
tell
that
you
I
who to
need trust
use.
accounts, but I know that that's been, for me personally, just researching, looking into it. I found that not a lot of banks offer that, but it's good to know that the division has
Yeah, there are quite a
lengthy
few.
list.
Yes. So, any further discussion, or would someone like to make a motion?
Erica, you're on mute. I see your lips moving.
There we go. Thank you. I will just tag on to all of your thoughts. I agree with the bulk of all of them, particularly, you know, with Renee and Bernadette coming from the areas of expertise that they are in. I do like the idea of having a branch for, you know, not only assisting if we needed, you know, subpoena issues, but for the customers being able to walk in. We all know how good it is when you don't get stuck on a 1-800 number in a loop trying to get something done, and you can just walk physically into an office and have somebody sit down with you regardless of whether you use checks or not. You're just like, I need help with X, Y, or Z. I think that's incredibly important. And if a loan production office can do that, I think that's great, but I don't think that they can do it at the level that you need to when you're talking about your checking account, your trust account. Those particular issues, I think, need a potentially higher level. So I think that the more conservative way, potentially what we might be dealing with in future issues. So the more conservative approach may be to have a branch in this issue.
Would you like to make a motion?
I would motion to require a branch location in Colorado.
Okay. Do we need to be more specific? Do we need to say a bank branch where they can actually go in? It's a fully functioning bank. You can go in, you can open accounts, make deposits. I'm not sure the correct terminology, but fully functioning branch bank.
I don't know if we need to have it more specific or not.
Okay.
I was thinking we kind of, to Renee's point, that we should spell that out just a little to state that it needs to be, and again, I don't know the terminology, but like a depository type of bank, you know, situation.
Bernadette, do you know the right verbiage on that?
I'm trying to think the same thing. I would say I would motion to require a physical branch.
Or Irina or Andrew, are you listening?
Yes, I'm here.
Anthony, sorry, not Andrew.
No,
Anthony.
you're fine. You're fine.
Do you know what the correct verbiage is?
I think a branch is fine. That's a term of art used in the banking industry. And typically it refers to exactly what you were kind of referencing, a place you can go in, open accounts, close accounts, deposit checks, etc.
Okay, so we'll go back to Erica's motion and not sure, Erica, what you said, but we'll specify in that motion that a bank branch is required in the state. So does anyone have a discussion or someone want a second?
I do have quick discussion on that. And where did Anthony go? Anthony, are you still there?
Yes, ma'am.
So one of the things that in the company that brought this forward, there was mention that they focus on lending and can't directly accept money deposits or disperse funds, but then it said, in contrast, customers can directly open accounts and deposit money in traditional branch offices. So it was kind of confusing there. So was there a physical the reason I'm asking this is that if we do have those instances where this branch could accept deposits, then do we define that as a branch, right? So that's the reason I'm bringing it up now.
Great question. My understanding is that the term branch refers to again, a term of art in the banking industry. It refers to a specific type of office location that can accept deposits. You can open accounts. A loan production office cannot do those things. My understanding from the correspondence that was submitted to you all is that you can go to a loan production office and you can talk to them about opening an account, but that would all be done at a branch which is not located in the state of Colorado. So
Okay. So when it mentions that in here, it's not referencing Colorado. It's just referencing in general.
it would be another branch at presumably one of their other locations. I think
Got
they
it.
have others. They have
Okay.
branches in other states.
Got it. Okay. Thank you for that clarification.
My understanding of this would be like you can go to a loan production office. There's a big bank out here in Colorado. They're in multiple states, but they have physical branches, right? Where you could go in and do transactions. They have locations where you cannot do any transactions, but you can go in and apply for loans. You can also go, there's other branches that do like financial planning, but you cannot do banking transactions. They don't handle money. They don't have a way to handle those money in, money out.
Okay.
So I would think like in this, my thought is, I mean, I think about some of the cases that we see, right? And they've got somebody that needs to give somebody their money back from, they're down to day 29 and they need to make sure that they get, somebody's money back. They don't have checks, so they could go in there and get a check and get it to their client where they can even have access to that money. There are clients like, I need this money. You're sitting on my money. I need this. I need to cash this today. I need this because I need it to put a deposit down on a property. I don't know. So I would think I could see the importance of having a physical branch to be able to do transactions. Now, I think if you walk into a place where they don't do transactions, they can talk to you about it. They can talk to you about what accounts they have or whatever, but they're going to direct you to online and
Gotcha.
you're going to be doing it virtually still.
Okay. Well, we can call the question. I just wanted that clarification on this because it was a little confusing, but I know the motion is
Yeah, Erica has made a motion about
Yeah.
requiring a branch bank in Colorado for all banks providing trust accounts here in the state.
I would
there
say
there was a second
motion-
already, right?
Yeah.
No, it's on the
Oh, no?
second?
Oh,
I
I
don't
thought
think so.
no one
I'll
second?
second.
Oh,
Okay, Autumn
okay.
second. Okay. Any further discussion? Okay, all those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes.
So
Okay,
Commissioners, the last thing on your agenda is whether you have any agenda items for the next meeting. Obviously, we will present revisions for CP22 and the HOA form that was kind of created as a suggestion for your above list.
okay. That would be great. I don't have anything else.
Mm-mm.
Okay, all right, nothing else. Let's take is 10-minute break good enough? Take a 10-minute break. It's 11:20. We'll be back here at 11:30.
Sounds
Perfect.
good.
Okay. Okay, it looks like we're all back. Next, we're going to move on to complaint and audits. Yeah,
Good morning, commissioners.
good morning.
Okay. Your first item is investigative matter A. This is audit number X 2024-14. The respondent entered into a stipulation for diversion due to results and findings of a previous audit, which resulted in this follow-up audit. The broker replied to the division's notification of audit and correction letter in a timely manner and corrected some of the issues identified. However, unresolved items remain with respect to the brokerage's errors and omissions insurance, standard forms, as well as trust accounts and reconciliations. The division attempted to coordinate a meeting with the respondent to discuss these outstanding items, but was ultimately unable to establish a meeting. The respondent was then issued a final notice to comply, but no response was received by the deadline. As of this report, the division still has received no further communication from the respondent. Possible violations include 12-10-2171I, 12-10-2171M for violation of any commission rule, 12-10-2171M for violation of the STIP, rules 3.9, rule 5.2, rule 6.25C, and rule 7.1. Recommended disciplinary action includes final agency order, a $1,500 fine, and a license suspension until the audit is completed. And myself and Auditor Andrew Orr are here to answer any questions you may have.
Did anybody have any questions on this one?
Just question on the suspension. Right now, the license is active. If we approve this as it is, their status will be changed right away to suspension. And then they are obviously notified right away as well. Correct?
No, commissioners, if they sign a stipulation agreeing to the suspension, then they will become suspended. Otherwise, if they don't sign a stipulation, the case will get referred to the AG's office. The AG will start the hearing process.
Okay.
So it's not automatic by any means.
All right. Thank you. Okay. Does anyone have any questions or want to make a motion?
There's no questions. I'll move to accept staff recommendation.
Okay. Do we have a second?
Second.
All right. Any further discussion? All right. All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Okay. Next is investigative matter B. This is complaint number 2025-1342. The respondent is an unlicensed person who has been managing 3 rental properties for the complainant for many years without a written agreement. The complainant resides outside the country and relies on mobile app messaging to communicate with the respondent. The complainant alleges that the respondent has been withholding rent payments totaling $56,000. The respondent states he has withheld payments with the complainant's authorization as repayment for management fees and repair expenses the respondent incurred maintaining the properties. The complainant served the respondent with a termination letter that the respondent has ignored. The complainant alleges repairs were not authorized. The respondent alleges repairs were authorized. Neither party can produce sufficient documentation to support their position, but does appear to be managing properties without a real estate license. Possible violations include 12-10-202 license required, and recommended disciplinary action includes an injunction. And I can answer any questions you may have at the moment.
Can you explain what that means? Once the injunction is filed, what happens?
I believe it is. Thank you. I see Irina is on camera.
Sure, Madam Chair. I'll probably will be in a better position to explain what happens because it's my office that prosecutes those type of cases. So because we have very limited jurisdiction because they are not a licensee. We're not going quite traditional route, but we're filing with the Denver District Court telling Denver District Court, look, this person is practicing without a license. Please stop them from doing that. And that's what we mean by injunction, attempting to obtain injunctive, sorry, my language, injunctive relief, meaning the court telling them stop, otherwise it will get worse.
Okay, so this actually is going to go to court and then proceed.
Right.
Okay. All right. Okay, does anyone have any other questions or someone want to make a motion?
My questions on my notes to myself is, do we even have any jurisdiction over this since he is not licensed? So obviously that answered the question with the injunction. My only, I don't feel that, like I don't know if he's really at fault. It's crazy, but I don't know if it's really legal for him keeping the money until he's paid. Because I think he only wants to be reimbursed. I really didn't believe the part where it says he's accepting Chinese money over American money, because obviously I think the American money is worth more. I can't see him doing that. So
Well,
our
Bernadette,
only
to my sorry, I didn't mean to interrupt you. To my understanding, this isn't necessarily for us to figure out blame or fault. It's really just this next step so they can figure it out in like small claims court, or but this is specific what it means to the Department of excuse me, hiccup, real estate. Am I
yeah,
accurate
we
with
can't
that?
really say a whole lot to it.
Yeah,
No,
so I think there's not much we can do.
Okay.
Okay, yep.
Would
So-
someone like to make a motion then?
I'll move to accept staff recommendation to move forward with injunction.
Okay, do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Okay, any opposed? Motion passes.
Okay, next is investigative matter C. This is complaint number 2025-2019. On November 7th, 2025, the respondent was sentenced to 1 count of felony menacing, a class 5 felony, and 1 count of violation of protection order, criminal, class 1 misdemeanor. The respondent was sentenced to 2 years probation, domestic violence evaluation, treatment, no weapons, substance abuse evaluation and treatment, no alcohol or non-prescribed drug use, and substance abuse monitoring. The conditions of the sentence run concurrent with 2 other cases related to the protection order. Possible violations include 12-10-2171M, 12-10-2171N, 12-10-2171P, and Rule 6.23. Recommended disciplinary action includes diversion, a $500 fine, and probation to run concurrent with the criminal probation terms. And I can answer any questions you may have.
Hi, Eddie. I do have a question. Thank you
Yes.
for all of that. When I was reviewing this file, it was noted that there was a prior charge in 2024, and that was separate from this. At least that was my understanding. But then when you look at the history, it didn't show that case was ever reported. So I didn't know if there was additional information on that, because it seemed as if it was missed, and it went unreported, which I think would maybe change my position on the fines and stuff if we have
That
any
is-
information on that.
That is a good question. I would have to go back and look at the original. So I think the answer to that would be that, yes, he was arrested. I don't know if there was a previous conviction. I do know that multiple convictions were kind of rolled into one with the information that was presented to you.
Okay.
There is, I believe, this respondent was also arrested after the fact and is awaiting further possible conviction.
And is it fair to say that if convicted, this will come before us again?
In the event that I believe they were to agree to whatever disciplinary action you would approve, and then they end up entering a guilty plea or being convicted after the fact, that would trigger a a need to notify the division of the conviction. Yes.
Okay.
Yeah,
Okay.
Erica, I zeroed in on that as well. I was like, why is this probation and not suspension? And it's because he hasn't been convicted yet.
Okay.
You said that he was arrested after the fact as well?
Yeah, I believe the investigative report reflects that he was arrested after these convictions.
Has he self-reported the other arrest or anything?
So I believe the rule in the statute requires them to self-report when they enter a guilty plea or nolo contendere, or they enter some sort of official plea, or they are actually convicted, not necessarily when they are arrested.
Yep.
Okay.
Okay.
So I think it's something we can, if it comes before us, then we can, deal with that then.
Do you want to make a motion then?
Yeah, motion to accept disciplinary recommendation as presented.
Any further discussion, or do we have a second?
I'll second.
Okay, all those in favor?
Aye.
Aye.
Aye. Any opposed? Okay, motion carries.
Okay, next is investigative matter D. The Division of Real Estate received complaint number 2024. I'm sorry. Investigative matter D, which is complaint number 2024-1699 and 2024-1803. The division received complaint 2024-1699 regarding a transaction that the respondent entered into with the complainants and owners of the subject property. The complainants and the respondent entered into a joint venture agreement that authorized the respondent to manage the subject property as managing investor with 51% ownership in the property. With the joint venture agreement, the respondent then entered into a lease to own transaction with the tenants complainants of complaint number 2024-1803. The property owner complainant alleges that the respondent didn't provide all transaction documents for review, forged or copied signatures, initials, and had her sign the joint venture agreement while under the influence of prescription medication. The complainants object to many terms in the joint venture agreement that the respondent was supposed to remove and didn't. The respondent also acknowledges that she called the complainant's mortgage company impersonating her instead of using their power of attorney in an attempt to make a mortgage payment. The respondent didn't disclose her side business or joint venture agreements to her brokerage firms because she believes she doesn't need to. After learning of this transaction from a negative online review, the respondent's previous employing brokerage firm terminated her employment as they felt this transaction was inappropriate. The tenant complainant as subject property paid an option fee to rent to own the property that the respondent has retained as non-refundable. Additionally, the respondent has retained the $1,000 security deposit paid by the tenant complainant. The respondent has not returned or provided any portion of the option fee or security deposit to either the property owners or tenants. The property owner has since terminated the contract with the respondent, evicted the tenants for non-payment of rent, and moved back into the property. Possible violations include 12-10-2171B, 12-10-2171H, 12-10-2171I, 12-10-2171M, 12-10-2171Q, 12-10-2171T, 12-10-2171W, and rules 5.9, 5.10, and 5.11. And recommended disciplinary action includes final agency order, public censure, revocation, and a $22,500 fine or max fines. And myself and investigator Marcy Rivera are here to answer any questions you may have.
I have a couple notes on this. I know in the investigation, it mentions that there is another venture property situation. Do we look at that to see what do we look into that, even though if we revoke her license, is anybody going to look at that what happens with that situation?
I believe we did inquire about it and get some information. There was no evidence to suggest, I believe that agreement, the information and the documentation we received showed that the transaction was working or was performing as contracted. Although we did want to have some sort of idea of how many others of
Mhm.
these transactions were out there that she was involved in. I think an argument is that, you know, the respondent is making is that this is a personal transaction, like they are a party to this transaction. So it is, in that regard, there is an element of non-real estate activity to it. So to answer your question, what can we possibly do after her license if she were to accept a revocation? I think once she accepts a revocation, that, you know, we have no more involvement necessarily with her.
Okay. Well, I would motion to accept staff recommendations on this.
Second.
Any further discussion? Okay, all those in favor?
Aye.
Okay, any opposed? Okay, motion passes.
Thank you. And I will see y'all in a bit.
Thank you.
Thanks.
Good morning.
Morning.
Complaint matter E is complaint numbers 2025-61 and 2025-1163. The investigation found that the respondent is conducting and promoting a real estate brokerage business under a name not licensed in Colorado. Additionally, the advertising of the real estate brokerage appears to be misleading. The investigation also found that the respondent does not establish this brokerage relationship with his clients. Further, the documents used in the respondent's transactions are not commission-approved forms, are not drafted by a Colorado attorney, and are not a client's form. Possible violations include 1210-2039, 1210-217-1A, 1210-217-1M, 1210-217-1Q, Rules 6.6, 6.10, and 7.1. Disciplinary recommendations are public censure, a final agency order, a fine of $6,000, coursework in brokerage relationships, coursework in contracts, and a sales file and advertising audit within 6 months. And Investigator Gabarty can help answer some of your questions.
Sorry, I'm going back into the file. From memory, this was a commercial transaction, correct?
Yes, that's correct.
Okay, and on the commercial, I believe it was a referral within the commercial brokerage network. Is that accurate?
That is accurate in that the next complaint that you're going to hear referred these two properties to the respondent.
Gotcha. So again, as a public member here, I have a little bit of commercial exposure. Is commercial subject to the same rules and regulations of residential when operating
Yes.
outside of state lines?
Yes, they're the same as residential requirements.
Okay. I wasn't quite sure on that, so I was like, I'm going to ask. So thank you.
Sure.
Well, I thought the discipline was appropriate, so I'm open to motion to accept the disciplinary recommendation presented by staff.
And I'll second that.
All right, any further discussion? All those in favor?
Aye.
Aye.
Any
Aye.
opposed? Okay, motion passes.
Complaint matter F is complaint number 2025-2327. It is alleged that the respondent is practicing real estate brokerage services in Colorado without a proper license, specifically through its marketing activities. And in this one, because they are not licensed in Colorado, we recommend a referral to the California Department of Real Estate. And again, Investigator Gabarty can help answer any of your questions.
The only question I had on this one, we didn't consider an injunction because they're out of state. Is that right? Or
Correct. They're licensed in California, and correct me if I'm wrong, Yvette, but they have, we haven't been able to find anything that they're currently, so for an injunction, I believe it has to be current and ongoing activity. So right now, the really only thing we are trying to do is refer it to California to have them look at the activity.
Okay, thanks for clarifying. I was just wondering why we didn't have an injunction on that one also.
Sure.
Okay, someone want to make a motion?
Yeah, motion to approve the recommended disciplinary action as presented.
Okay, do we have a second?
I'll second.
All right, any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes.
Complaint matter G is complaint number 2025-209. The investigation.
Commissioner, I'm sorry to
Yeah.
interrupt. Commissioner Rubal, is that the one matter I believe?
Correct.
Okay.
Yeah,
go
so I am going to be recusing myself due to actual or potential conflict of interest, and I will be leaving the meeting. And I'll have you guys notify me once you are done with your review. Thank you.
Okay. The investigation substantiated the anonymous complainant's allegation of the respondent practicing real estate with an expired license. The investigation also found that the respondent did not have E&O insurance in place while practicing with an expired license. The investigation further found that the respondent failed to maintain possession of transaction documents. The respondent failed to provide the consumer with written disclosure of the respondent's brokerage relationship by use of a required commission-approved form. Possible violations include 1210-217-1K, 1210-217-1M, 1210-405, 1210-204-1, 1210-217-1Q, Rule 5.21, Rule 6.5, Rule 6.20, and Rule 7.1. Disciplinary recommendations are public censure, a final agency order, a fine of $5,000, and coursework in brokerage relationships and coursework in contracts. And Investigator Gabarty can answer any of your questions.
I first have to say I will agree with the staff recommendations, but I do have a question. Listening to the I guess the interview, do we look at that his I guess claim about the lady that was working for him and her I guess messing with the commission with their commission, I guess. Is that something that we look at, or no? Is that even something that we would even talk about? I don't know. I'm just curious on that piece.
We don't get involved in any commission disputes. Is that what you're referring to?
Yeah, that's kind of what I was looking at, if there was issue with that, but okay.
My only question on this and thoughts on it is the one thing that stood out to me is that this particular individual, this has been a reoccurring theme, and this individual also has licensees under him. So every time he doesn't renew, it affects the licensees, some of which I guess it's unclear. As of the date of this report, they weren't active still. So I felt that the fine was very generous given the extent of this. And also I was curious, and I can't remember the course, but I mean, I almost think because this is a reoccurring thing, I definitely think we need to be a little bit more aggressive because he's not getting the message. I don't know that he should be an employing broker, so I don't know if it's downgrading a license. I don't know if it's recommending he retake that 8-hour course. I don't know that brokerage relationships is enough. You know, I think we need to, if we're gonna allow him to maintain managing broker status, then we add in that 8-hour course. I just don't remember the name of it. And then maybe if we do that, I don't know. I thought the fine was very generous. So I think that fine should be a little bit higher.
So would you like to see him downgraded to an FA?
I think he should be if this is a reoccurring. Do we know how many incidents? Do we have that tracked, Nicole?
Let me pull that up real quick.
Okay. If it's happened more than 2 times, this is now a theme.
Could you repeat the question with regard to incident? What are you referring to with regard to incident?
I'm referring to the fact that it was noted in the report that this is that he has a long history of failing to renew his license, causing his license and that of the brokerages to be inactive for long periods of time.
Okay, I understand.
And so the associate brokers are becoming inactive every time this happens. So it's affecting the associates.
Correct. At the time that I wrote the report, he didn't have any associate brokers. At the time the license went inactive, he did. And so that therefore caused the license of not only the brokerage firm, but his associate brokers to go inactive. They haven't since activated their license, and which is totally up to them whether they choose to. But there is an exhibit with regard to his history that shows how many incidents, as in how often he does that, fails to renew his license, which then causes the brokerage firm its license to go inactive.
So to the other commissioners, what are your thoughts on that? I mean, I think we need to be a little bit more aggressive, but if he doesn't typically have associates, I guess it's not as impactful to them as I at least thought, but maybe requiring that broker administration course or whatever that is, that 8-hour course might be a good.
I agree with you, Erica. I saw that note about having a history of non-renewal with his license. It let his E&O lapse. He was closing a deal. He closed a deal while he was inactive, and then blamed no notification, even though there's multiple direct emails from the commission regarding the renewal. So I think, it's just not been a big deal to him to do that. So I'm fine. I do think that because even if he doesn't have licensees underneath him right now, he needs that course. So I think that at a bare minimum, we should be adding that on.
Are you wanting to downgrade him or not?
I'm looking at his history real quick.
Commissioner Sanders, I'm not sure you got your question answered on the number of times.
Yeah, that's what I'm looking at. I'm
And
trying to
it does
look, I'm pulling the
appear that
history.
1, 2, 3, 4, 5, at least 5 times he's been inactivated due to an E&O audit.
Okay. I mean, I'm going to be honest. I think he probably should be downgraded.
Yeah.
As an employing broker, that's just not acceptable.
So you want to downgrade him for 2 years? What do you want to do?
Is it typical? I'm trying to think of what I've seen. I believe what I've seen is that it is a minimum of 2 years when we do a downgrade. Is that typically what we do?
Yeah, it's kind of like starting over.
Yeah.
We have done that quite a bit in the past.
Yeah. I think a downgrade is appropriate. Then we can eliminate the need for the course, because he'd have to retake that course. Is that correct? In order to be upgraded.
That's correct.
Correct.
So I think a downgrade, and then we can keep all the other, in my opinion, we can keep everything else, but the downgrade definitely should be.
You want to make a motion?
And Erica, remind me, did you say you wanted to keep the fine the same, or you wanted to change that fine as well?
I think if we're gonna downgrade his license, then I would
Okay.
be a little bit more comfortable with a fine. I wasn't comfortable with the fine based on the severity,
Mhm.
but I think with the downgrade,
Okay.
anyone else want to chime in on that?
I think that's fine.
Okay, someone want to make a motion?
Motion to accept staff recommendation with the addition of a downgrade to the broker license for a minimum of 2 years.
Okay, any further discussion or? Okay, do I have a second?
I'll second.
Okay, all those in favor?
Aye.
Aye.
Okay, any opposed? Okay, motion passes.
Matter H is complaint number 2025-1.
Mr. Mahoney, if you could hold on just one moment while
sorry.
Autumn rejoins. No, not a
Sure.
problem. A message has been delivered to her, so she should be back in just a moment.
Okay.
Autumn, do we have you back?
I'm back.
All right. Thank you very much.
Thank you.
Okay. Matter H is complaint number 2025-1776. On August 20th of 2025, the Nevada Real Estate Commission entered a findings of fact, conclusions of law and order, refusing to renew the respondent's Nevada real estate salesperson's license for 3 years. The order also called for a fine of $15,473.67. The fine balance remains outstanding. On April 11th, 2024, the respondent entered into a stipulation for diversion with the Colorado Division of Real Estate. The stipulation called for a $250 fine and probationary license concurrent with the respondent's criminal case. The terms of the stipulation for diversion were completed on December 22nd, 2025. On December 15th of 2023, the respondent pled guilty to assault to strangulation, a Class 4 felony. The respondent was ordered to complete a 2-year deferred judgment with probation and pay $1,661.50 in court costs. The deferred judgment was completed on December 1st of 2025. The Nevada order was a result of the respondent failing to disclose disciplinary action with the state of Colorado, as well as his criminal conviction. The Nevada discipline was reported to the division on September 19th, 2025 through email from the respondent's attorney. Possible violations are 1210 to 171X, and disciplinary recommendations are diversion and a $500 fine. And Investigator Martinez can answer any questions.
The only question I have on this one, he did self-report to us, right? That's what I show.
His attorney did self-report to us. Yeah.
And then normally I see that we usually do a $250 fine when it's self-reported and then like 500 when not. We've even seen that today. So I'm just wondering why it was a little bit more.
I want to say that was because the fine was still outstanding.
Okay.
But we're open to changing it however you'd like it.
I just, I was looking just for consistency if we're, I don't want to, there's a little bit of reward, I guess, when someone does what they're supposed to do. But I don't want to really give the same discipline that we gave someone who didn't do what they were supposed to do, if that makes sense. Do we have, Mr. Martinez, do we have clarification if it was because the fine wasn't paid or?
I don't get to make the decisions on the fines. So I think Nicole probably.
Oh, Nicole, I'm sorry.
Well, was the fine still outstanding because he was still going through some of the process in Nevada?
So there's no explanation as to why the fine is still outstanding, but it is currently still unpaid, and there's no payment plan in place with no payments having been made yet.
Okay. Well, and let's see, the STIP that just completed, that was December 22nd, so that was still pretty recent.
Yeah. I would say 250. Let's just stick with what we traditionally do.
It could also be because it's his second one. He already had one that he got charged 250 for, and this is a second one. So that could be why it's now 500.
Yeah, that's exactly why.
Okay.
So if it's the second one, Erica, are you comfortable maintaining the $500 fee?
Yeah. Yeah, because otherwise I'm assuming it would have been a higher fine if he had not self-reported in that case. So then yes. So
Okay, you want to make a motion?
yeah, motion to accept the staff recommendation.
We have a
I'll second.
Okay. Any further discussion? All those in favor?
Aye.
Any opposed?
Aye.
Okay, motion carries.
And before we go into the next discussion, I know a couple of us have to recuse. So I will be recusing from investigative matter I for actual or perceived conflict.
And I will be recusing myself due to possible actual or perceived conflict. So.
Okay.
All right. Bye.
Are we okay to go?
Yep.
Okay, investigative matter I is complaints, there are two complaints, 2025-444 and 2025-524. I'll summarize the first case, 2025-444. The respondent represented the complainant in the listing of her existing property and the purchase of her replacement property. The complainant alleged that the respondent committed the following violations: signed her name to the purchase contract, the counterproposal, and the buyer agreement without her knowledge or consent. Wrote the offer as a cash offer contrary to her requiring a loan to purchase the property. Lost her $7,500 in earnest money due to failure to properly represent. And listed her existing property for sale without an executed listing contract. The summary for case number 2025-524. The complainant was the listing agent for a property in which the respondent represented a buyer on a failed transaction. The complainant alleged that the respondent committed the following violations: signed the buyer's name to the purchase contract without the buyer's knowledge or consent. Signed the buyer's name to the counterproposal without the buyer's knowledge or consent. Wrote the offer as a cash offer contrary to the buyer requiring a loan to purchase the property. Possible violations include 1210-217-1M, 1210-217-1Q, 1210-217-1C, 1210-217-1B, 1210-217-1W, 1210-405, and 1210-404, Rules 6.5, 6.14A1, 6.14C, and Rule 6.6. Disciplinary recommendation is public censure, a final agency order, revocation, and a fine of $25,000 or max fines. Investigator Peters is not here, but I can try to answer any of your questions.
Any discussion?
Ugh. There was a lot in this one. The fraud part was was a huge issue for me. That was probably fraud is, I guess, a big hot button for me. So, I mean, if I recall correctly, respondent has been an active agent, I think, for almost 20 years. And I'm not one to really want to say not all situations to revoke somebody's license, but I keep coming back to the fraud piece. That's probably that was huge for me.
Yeah, Bernadette, to jump on that, if they've been a licensed agent for that long, they knew what they were doing.
Yeah, and so fraud is it's a hot button. So I would accept the staff recommendation of the disciplinary action on this one for sure.
Okay, are you making a motion?
Yeah, I'll motion to accept staff recommendation for the disciplinary action.
And I'll
Okay.
second.
All right, any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes. And before we go to J, we need to get both Ericas back.
Commissioners, they have both been contacted, so they'll be rejoining here shortly, I'm sure.
Thanks, David.
Sorry.
They didn't realize we were going to be so quick. They probably went to get lunch.
Right?
All right. Sorry about that. I clicked on the wrong link.
Okay, matter J is complaint number 2025-107. A prospective tenant filed a complaint against the respondent, who is the employing broker for the property management company. The complainant paid a $250 holding deposit to the property management company, who is managing the 200-unit apartment complex. The complainant's application was denied. After contacting the property management company numerous times requesting a refund of the holding deposit, it still had not been returned at the time he filed the complaint, which was 2 months after he had paid it. The investigation found that the complainant's holding deposit was not returned for 2 months. In addition, the investigation found the following potential violations. The owner paid a $500 penalty to the potential tenant for the late return of the holding deposit out of the operating account, the owner's operating account. The holding deposit was placed in a business operating account, not a separate trust account. The tenant security deposits for the apartment complex were being held in the business operating account, not a separate security deposit trust account. Possible violations include 1210-217-1M, 1210-217-1I, 1210-217-1K, 1210-217-1Q, Rules 5.5, Rule 5.9, Rule 5.10, Rule 5.14, Rule 6.2, Rule 6.3, Rule 6.5, and Rule 6.6. Disciplinary recommendations are public censure, a final agency order, a fine of $10,000, coursework in property management, coursework in trust accounts, coursework in brokerage administration, coursework in brokerage relationships, an audit within 3 months, and a license downgrade to an associate with a high level of supervision for 2 years. And I will try to answer any of your questions.
I think for me, I would have added ethics to the list of additional education.
And my notes were, I think an additional audit.
After
In
3
addition
months.
to the
I think there should be 2 audits, not just the one.
So 3 months and then 6 months?
Mm-hmm.
Okay. How about you, Renee?
It's fine. 3 months, 6 months. Okay.
Bernadette?
I agree with what they've said. I'm fine.
Okay. Someone want to make a motion?
I'll move to accept staff recommendations with the addition of coursework and ethics and the addition of 2 audits, one at 3-month duration and one at 6-month duration.
Okay. Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Matter K is complaint number 2025-1734. The Colorado Real Estate Commission opened a complaint against the respondent due to the discovery of an unlicensed property management company being operated within the brokerage. The employing broker maintained that her husband, who was an associate broker of the brokerage, would not provide her the ability to supervise the property management activities. The property management company was found to be in violation regarding trust accounting, standard forms, and brokerage disclosures. Possible violations include 1210-217-1M, 1210-217-1Q, 1210-217-1R, Rules 6.10, 6.3, and 6.5. Disciplinary recommendations are a final agency order, diversion, a fine of $5,000, and coursework in brokerage administration. And Investigator Geske can answer any of your questions.
I definitely have questions on this one.
Yeah, I have a question too.
Okay. So first question is, where is the complaint on the husband?
Yeah, that's my question.
Yeah.
And yeah, so we all are
I
on the
think
same
we all
page
have
there.
that.
Yep.
So we'll let you answer that one first, and then I have a follow-up question.
So that one was presented already, but it was in a different commission meeting. The complaint against the husband came in for license or advertising. So while we investigated that, it turned out to be a letter of concern was the discipline. However, once we started investigating that after it was closed, we determined that he was operating a property management company under his wife's firm without her supervision.
So should his stuff be changed instead of letter of concern? Should we go back and change what his discipline should be?
We have added him to an audit list. So the audit team will be looking into.
Sorry to interrupt. There is a new complaint that CREC has initiated against the associate broker.
Okay.
Okay. Well, with that said, I mean, looking at the violations, I believe that this individual violated in terms of, all the statutes are fine, but I think that in terms of rules, the violation is 6.3. I don't believe that it's the advertising or the broker's disclosures because, potentially this individual was unaware of what was going on, didn't have control, but definitely should take responsibility for the lack of supervision. And I think that those other charges are more appropriate with the husband.
Just
the other two rules.
The advertising was because after he had gone independent and went on his own during the investigation, she continued to advertise him on her brokerage firm site for quite a while.
Advertise the property management services?
The associate broker, who was her husband, who was no longer with the company, she advertised him under her firm for a while after he had left the firm. That was the reason that was thrown in there.
Okay, that makes
So,
sense.
Okay.
And then during the interview, one of the, it might have been the wife that said something to the effect of, I can't remember, it could have been him. I actually might have been him that said other agents in the brokerage once if an opportunity came up that was a referral to him in the office, but he was an owner of that. He was a part owner of that brokerage, but there was brokers in there that were referring him business as well. So I think I can't say as much as she says she didn't supervise it, like I get it, but we're looking at 10 years.
It started, it was transferred to the brokerage in 2011.
He transferred because it was a property management company before. And
Correct.
then when they opened up the brokerage, he transferred it over there and changed the name to the same name, or close to it. So I get that she says, I mean, you're looking at still 10 years of no supervision of, and her saying, but it was advertised he was working out of the office. I don't know.
If you went, you're saying they bought a PM company. If it was a PM company and then they made it into the brokerage, then she would have known that they were doing property management because that's what the business was.
Yeah, they had one beforehand is what in the interview, that's what it says, that they had one before. And it was like
in no way that she can say she didn't know he was doing that.
Well, and I don't think she ever denies that she knew that he was doing it. The only thing she says is that she had no knowledge of anything that was going on with it, but she's the employing broker and still says over the past 10 years she had nothing in it. He just always said, it has nothing to do with you. It has nothing to do with you. I don't know if I can say that's okay. I don't, and she's the employing broker. I get it, but it's her name, her license. It's under her. And there's the example of how many agents did she say that was there? Like, I think she said like 80 or 90.
87.
Yeah, there's a lot. I mean,
getting referrals from that too. I don't know.
Yeah, my issue is not her discipline because she should be disciplined. My issue is that I didn't see anything come over for the husband who clearly knew that he was engaging in property management. I still hold that I agree with the advertising now that that's been explained. I think 6.3 of obvious, right? There's a lack of supervision. I think 6.5, I just don't know that we've completely proved that she was part of the activities and that the brokerage was part of the activities. So I don't agree with 6.5, but it doesn't really change the overall perspective. So I still agree with the discipline. I just don't agree with 6.5 more of it from a technical standpoint. But I do agree with the recommendation in regard to the discipline, but I would just remove 6.5.
I think with the so 6.5 brokerage relationship disclosures in writing, he was one of the owners of the
But that's him. That's not her.
But they're together. They owned it together. They owned the brokerage together, and then he's getting referrals from everybody that's in, you're talking 80 something agents out of the office.
But it still, to me, doesn't prove the brokerage relationship in writing. If they are two separate entities, I think that falls on him, not her. But again, it doesn't really change the discipline. But I think technically I would not put that on, I would not put that as a rule that
Todd,
she violated. I think he violated that rule.
Is there what?
Is there a reason that 6.5 is on there for her?
Due to her supervision of the property management company within her brokerage.
Okay, so Erica, that's why it's on there.
Because they said that he worked out of the office,
Correct.
out of the
I think she
brokerage.
made an intentional decision to let it continue, and you can only say, I didn't know for so long. I think she decided to let it continue.
For 10 years.
Agreed. Which is heavy on the supervision.
Yeah.
And I think that's why I think that fine is appropriate too. So that's what I'm saying. The discipline, I'm not recommending changing that or reducing it by any means, but I just find it hard to, based on the information we have, to say that I just think that that 6.5 violation should be under the husband, not her.
Well,
But
this
again,
isn't the last.
doesn't change the outcome to me. I think she has to take responsibility for knowing and for just, showing a blind eye to this whole incident.
Well, this isn't the last that we're going to see this. Sounds like we have another in the queue for our next April meeting that is more specific to the husband. So just maybe put this in your memory banks. And
Okay, does someone want to make a motion?
Commissioners, if I may, before you motion on this one, on the referral, it has both final agency order and diversion checked, and I think Nicole stated both of those, but it's my understanding that it's just a final agency order, so just disregard the diversion on this recommendation.
Thanks, Penny.
okay, so we're moving to accept staff recommendation with the modification of deselecting diversion as an error. And then Erica, are we maintaining 6.5 or were we?
I think we remove it.
I think we leave it in there.
I think we leave it in there.
I'd leave it in.
Okay.
All right, so
the majority has spoken.
moving to accept staff recommendation with the only modification of deselecting diversion because that was a clerical error.
Hey, is there a second?
Second.
All right, any further discussion? All right, all those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes.
Matter L is complaint number 2025-1130. The complaint alleged that the respondent was operating an unlicensed property management company. The investigation found possible license law violations related to unlicensed property management activity, trust accounting, brokerage disclosures, E&O insurance coverage, unauthorized and unlicensed individuals signing lease agreements, and standard forms. Possible violations include 1210-217-1Q, 1210-217-1M, 1210-408, 1210-217-1I, Rule 3.9, Rule 5.5, Rule 5.10, Rule 5.11, Rule 5.14, Rule 6.2, Rule 6.5, Rule 6.17, Rule 7.1, and Rule 5.2. Disciplinary recommendations are public censure, a final agency order, a fine of $8,000, coursework in brokerage relationships, coursework in trust accounts, coursework in property management, and an audit within 3 months. And Investigator Geske can help answer your questions.
I do have one question on this one. This individual was managing a couple properties that were his. So when we are talking about the audit, because there's some things that we have to have in place, like trust accounts, etc., when we are managing properties. So are we looking at those things, or what is the audit focused on? I'm just trying to determine if one or two would make more sense.
Okay. The audit would focus on both. The properties that are being managed for others would include anything that he owns less than 20% of in an LLC. And there are still requirements as far as trust accounting with properties that are his own.
Okay.
So it would look at both.
Okay. Because I know he mentioned in the statement, which is probably a good idea, that he would not be managing other people's properties.
And this is a prime example of why we need a property management license with required classes. All this property management stuff we're getting, no one knows
Oh,
what
yeah.
they're doing.
For sure. And you'll probably see a theme in my recommendations, and as we get further, I'll go into it more. But I think with property management, like maybe that other audit would be warranted if especially if he's going to continue to do property management, which we don't really know. He's saying he's not, but we don't know until the audit. So I'm going to just see what the fellow commissioners feel about adding just one more audit. So it's 2 audits.
I think that makes sense and establishes consistency with what we've already done today.
Well, the other thing is when they do an audit, if there's an issue, then there'll probably be a request for a second one. Isn't that correct?
Usually, yes.
Yeah. So I don't know if we need to say 2 right now. We can say audit, and then if things aren't correct, another one will be coming.
But what if everything is correct? I think that's what Erica's trying to
Well, if
get everything
everything's
right for
correct,
the
that's
first audit.
great.
Well, you can get everything right for the first audit and fly under the radar and then have everything kind of mingled.
People can't even get an audit correct after having multiple and multiple and multiple. Doesn't mean you're going to get it all correct on an audit. There's a lot of stuff to do and fix.
Okay.
Yeah,
I'll
'cause
defer to you, Renee. You know best.
If I recall, I think he said he had was it 17 of his own, and it was I think what he said is that he wasn't going to manage anybody else's properties because he was doing them as favors or whatever for I think 3 of them, and he's like, after this, I'm not doing I'm not doing anything for anybody. He was
Which is
not
smart, but he still has his 17 that didn't have proper accounts and et cetera, et cetera. So I'm in favor of 2 audits, but we can motion and see what
I think it's okay to do 1. If there's an issue, there'll be a second one.
Okay, motion, somebody?
I'll motion to accept staff recommendation.
Is there a second?
I'll second.
Okay, any further discussion? All those in favor?
Aye.
Aye.
Right, any opposed? Motion passes.
The investigative matter M is complaint number X 2025-27. This audit was opened based on a signed stipulation agreement, which stemmed from a previous complaint and investigation. Several new items were identified but corrected during the audit, and ongoing concerns surrounding trust accounting practices corrected during the audit. The final notice requested an explanation and affirmation from the broker regarding his practice of allowing negative ledger balances, true negatives, which were indicative of conversion and diversion. Additionally, the requested on multiple occasions full substantiation for charges on the owner statement for an apartment complex was not provided. Possible violation is 1210-217-1M. Disciplinary recommendation is a final agency order, a fine of $2,500, and then an audit within 6 months. And Auditor Betsy Meredith is here to answer any questions you may have.
So hi there. So I alluded on this last one prior to this that there's a reason I was thinking about these additional audits. What I noticed as a theme, at least with the complaints this month, is, and Renee, you pointed this out as well, there's a lot of non-compliance with the audit. However, to me, it seems as if the PMs are really cooperating, most of them. Like in this case, property managers cooperating, but just having difficulty complying for whatever reason. And this is a theme that we're going to see kind of in this for the remainder. So I wanted to have a little bit of a discussion about that. And I don't know, my thought process is just how the other commissioners feel about, especially when you have individuals that want to comply, they're trying to comply, but maybe they're having a difficulty in certain areas, to do more of a minimal fine and allow that second audit and just see at that point if they can kind of get it together. And then if they can't after that next audit, then we could be a little bit more aggressive. But I kind of want just, with these individuals that are trying and they're really trying to cooperate and they're really trying to comply, I mean, I just would like us to consider allowing them the opportunity to,
Hey, this person had a lot of time. The stipulation for diversion originally was 12/30 of 24. So, so they had time to fix it, and then they had another audit, and things are still wrong. You can fix these things. They're all fixable. You can figure it out and take care of it. To not have them fixed a second time is kind of unexcusable. You know what you're supposed to do. They help you. I mean, when you're doing an audit, the idea is that they're helping you. They're not just trying to get down on you about it. They're trying to help. And they're telling you what you need to do. You need to do this stuff and fix it. So for audit after audit after audit to be wrong, there's something more going on. There's a bigger problem because these things are fixable.
So what I'm noticing, one of the issues with some of these are trying to recover from these negative ledger balances.
Okay,
And
that's easy to fix.
And people are having a lot of trouble with that. I don't know why. I don't do property management, but they're having a lot of trouble with that. And I'm trying to see on this one what the other issue, because a lot of it was, from what I recall, a few of the things were resolved. I think there was like one thing that wasn't.
Yeah, this broker, and forgive me, I've been fighting the flu, so this broker has made a lot of effort towards compliance, and I did want to bring the commission's attention that there was a typo in here. It says he provided an affirmation and then he didn't. He did provide an affirmation about how he will ensure moving forward that the negative balances are no longer there, and that was satisfactory. The only thing outstanding on this one I wasn't given the complete set of documents for a full review on one of the samples, but otherwise this broker did get this into compliance.
And with that, thank you so much for that. And with that, I mean, my position on it would be to do a smaller fine, add another audit, and be more aggressive at that time if things aren't in place. And a smaller fine somewhere in the realm of like 500 to 1,000, and then a second audit. And then if still they're non-compliant, then at that point we could be a little bit more aggressive with the fines and the discipline. But because there's a few of these today, there's a theme here, and I don't know why, but property managers are having a lot of difficulty here, even when they're trying to comply. So I just want to give a little grace and allow them, a little bit of opportunity to right their wrongs, especially when they're complying.
Problem is that the amount of time and energy it takes the investigator to go through and do an audit. It's not like you look at one thing, because you look at one thing and that leads you to another, to another, to another. It takes lots of time and energy. And honestly, this fine of $2,500 is dirt cheap if you look at other states. Other states are charging $8 to $12,000 for an audit. So honestly, our fine and an audit is really cheap. And I understand what you're saying, that they're trying, and that's great, but you need to get it right. And this is really a very inexpensive fine if you look at what other states are doing. So,
And isn't this one of 2 audits, Ms.
That's
Meredith?
correct.
Yeah.
This was the first of 2
So this
required
is the
audits.
first of 2. So, I mean, you know, there's already a second audit. Okay. What I'm recommending is that we don't go as aggressive on the fine, allow this individual the opportunity. I'm going to recommend maybe $1,000 fine, and then get a little bit more aggressive with that second audit if it's not up to par.
But I'll just jump in briefly. Eric, I can see where you're coming from on this because and it's particularly interesting when we have so many of these follow-up audits back to back to back. I mean, that was very interesting to read these because you can see at that point, one, to Renee's point about how hard these investigators work on these audits. There's so much information that they have to do, but 2, you can see how hard the property managers are working on this, and you can see the strides that some of them have made. And so to this one that we're talking about, my notes, I mean, it say that they really had momentum moving forward with the necessary corrections. They were reconciling, and the brokerage overall seems to be in compliance. And then you can compare that to some of them that are forthcoming where, you know, we didn't even have some responses. I mean, so there are those, and we want to take that into account. I would like to take that into account as well. So I see your point. I do see, Renee, your point on this as well. And how do we balance that when we have all of these that we're addressing? So I don't know what you do with that, but I think that is important, because we are looking at some where they have taken leaps and bounds to try and get everything corrected, but are still missing something. And that's why those audits are in place, to try and get just that last bit wrapped up. But I want to let them know we see the efforts that you've gone to try and correct that. And I appreciate Betsy's clarification on that as well.
Anyone else have thoughts on that and thoughts on reducing the fine?
I could see both sides of what you guys are saying. The money that we make, I guess the money that comes in based off of these fines basically runs the department, I guess. And how long does it take to do an audit? Do we have anybody that can tell us how long? Like,
I can speak to that on the upper on the audits like you're seeing of mine. Each of these audits, when it's a stipulation audit, it's truncated, right? Because we don't continue to give ongoing corrections. We do give a final notice. But from beginning to end, these audits can take, you know, sometimes the more complex ones, you know, 2 to 3 months when we give them the lead time and things like that. They can be longer, they can be shorter, but for me personally, that's what they tend to be.
And keep in mind with this one, there's already an audit that was gonna happen. So we're not adding an audit.
Yeah, there's
We're
already
just
one
saying reduce the fine so that and then be more aggressive on the second audit.
And they had a year to come into compliance, right? Because it was done in December of 2024 is when it was initially handed down.
Correct. He had a substantial amount of time, and I had opened this audit actually inadvertently prematurely because of the stipulation, and then I was out on extended leave over the summer, so he had substantial amount of time, you know, on this particular audit. This was a unique one that took a little bit longer.
I would probably leave it if he's had a year, though, Erica. I think he's had a year's a fair amount of time to try to get everything in order. In my opinion, I would think a year is plenty. We look at some of these other ones, and I don't know if they get a full year to come into compliance for their, you know, first audit after it's been handed down. I'd probably leave it. Anyone else?
My opinion is to accept staff recommendation.
Okay, do we have a second?
I'll second.
Okay, any further discussion? All those in favor?
Aye.
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 Any opposed?
I'm gonna oppose only because of the fine.
Okay,
So I'm gonna
motion
oppose.
passes.
Right, investigative matter N is complaint number X 2025-145. Respondent was placed on probation and required to successfully complete 2 successful audits. The previous complaint centered around undisclosed markups, and the previous audit indicated that there were undisclosed markups. The assigned stipulation stated that the broker must provide a pricing sheet to include markups and expressly noted that the disclosure on the website was insufficient. The initial updated lease and management agreement did not include the pricing sheet for the owners and tenants to sign. Instead, the lease and management agreement were updated to include links for the tenants and owners. After a final notice was sent on the stipulation audit, new documents were provided that moving forward, the maintenance price sheets and markups will be provided. However, there's no evidence that new tenants and owners between January 14th to November 2025 were provided with the pricing sheet. Additionally, the stipulation indicated that any violation of license law would constitute a stipulation violation. During this first stipulation audit, the 3 sampled files included non-executed radon disclosures. Possible violation is 1210-217-1M, 1210-217-1Q, and the disciplinary recommendation is a final agency order, a fine of $3,500, probation, which will remain ongoing per the previous stipulation, and we are recommending a second audit. And Betsy Meredith is here to answer any questions you may have.
So
My notes are kind of the same as the last one on this one. This is just, there's several in here moving forward where they're in compliant, but there may be like one thing or so that is out of whack. Sounds like he responded timely. He terminated the EPP plan, which was the most concerning part of this whole thing. And I've noted he's currently non-compliant on the pricing sheet, although it's detailed on the website. And then he's non-compliant on the radon disclosure.
No, they sent that new exhibit with the dealing
Oh.
with the radon disclosures, and the radon disclosures were completed.
Oh.
However, they weren't done very well. They weren't filled out very well as far as the location, type of system, etc., but they were signed.
Okay. And I may have reviewed it before that, so.
Yeah, there was another file on that, so
Okay.
that was okay.
So that was done. So now so the issue, I guess, Miss Meredith, you could let us know, is the outstanding thing just a pricing sheet?
So I went back and looked at in the January 2026 update, I went back and looked, and the radon disclosures that were referenced were completely blank. I did not, and I make room for missing something, but they were incomplete, boxes not checked, they weren't fully executed. So that was that still remains in there as the non-completely they weren't fully executed. And then the pricing sheet, they did provide evidence that moving forward, the tenants and the owners will have the full pricing sheet. It was that window of time that it appears that the owners and tenants only have the link to the website. So there was a window of time and a gap that seemed to be missed.
Yeah. Yeah, so my notes on this are almost identical to the last one, which is keep everything else but reduce the fine, especially since there's further audits, and then get more aggressive as we go.
I have a question on having a website link for pricing sheets versus a physical sheet. What are the reasons behind not allowing a website link for that? I mean, I can see it's nice to have something physical, but you can update it quicker. Consumers are used to going to websites for information. I mean, is that not allowed and I'm not aware of that?
My guess would be that it's because they can change the prices.
Well, the prices
And-
do change, but they can check that before moving forward on something. I don't know.
That's a great question because I thought the same exact thing. The only thing that I did note, though, in regard to that, is the stipulation specifically said it needs to be a pricing sheet, not online. I think it said that explicitly, like it needs to be pricing sheet and not online only. But I agree with you. I didn't understand the problem with the online other than maybe some people don't have access, etc. But I did see that they provided it. I went to see it to see if that link was good. It was. So, I mean, I
So
think
you're correct. It was called out in the stipulation specifically that just listing the website was insufficient.
So I guess my question, and this might not be the appropriate place then because we're dealing with this particular case, but then maybe it is because I want to know moving forward if that would be something we allow or not. And if that is, it's in this particular person's stipulation, then they, comply. But I would want people to know if they can provide a website link for that information because it is something that changes on a regular basis. And how do you get that information out to the consumers quickly and accurately? And that is the most common way of getting information out right now that's updated. I don't know, what's everybody's thoughts on that? Or should this decide for another time?
Yeah, I had the same thought. I didn't understand like the why it wasn't acceptable, but I also understood that it was stated it wasn't acceptable and it was, but I agree. I don't really understand
Well, I think
why it
there's
was an issue.
maybe a level of proprietary information there. People who are employed and earning an hourly rate could deduce the markup of the property managers, creating potential issues. I foresee that as proprietary information as cost of doing business.
Yeah, I'm not sure.
I'm not sure the conversation when you originally reviewed this, but because it was specifically included in the stipulation, I think that there probably was some conversation surrounding it at that time. I can tell you specifically right now what that conversation was that the commission had.
I'd like to at least get a feel for the other commissioners to see if, in this case, we would be open to reducing that fine. I went back down to 1,000 and then get more aggressive on the second audit.
I want to go back to the radon disclosure because I'm looking at them right now. They are signed and marked. Now their check mark in the boxes in number 2 and number 3 is like a little line. So their check mark needs to be better, but the information is filled out in it and they are signed. So I'm looking at the stuff in the leases now. So
are you on exhibit 13? Because this
I'm on exhibit 9. I'm looking at the first lease. I've looked them all up. If I go to exhibit 9 and go to the lease and you click on the lease, it's almost at the very bottom. It's like the second to last page is the radon disclosure, and it is filled out and it is initialed and it is signed. And I've looked at all of the leases that are referenced in here and they are completed. And there was a letter from the attorney about that saying that maybe they uploaded something incorrectly, but here's the correct, and they are done.
So what's interesting, and I had run this by Sarah, I wonder if there's something with the PDFs, because the ones that that one I'm looking, I opened a ball again and triple checked. They're all completely blank. So I don't know if
exhibit 9.
Yep.
And then you click in the lease PDF and it's a second to last page.
Yep, I'm looking at it.
And mine
And you're seeing a check mark?
Yeah, there's that little teeny mark. There's a little teeny line. It looks like an exclamation point. So it is a really lame check mark, but there is a line in the circle on number 2 and number 3. And then I have initials below it, and I have names and dates on the next page.
See, it's interesting because on that PDF, page 64 and 65 of that PDF, and this begs the question, is there some reason that my software program is not recognizing these? Because I have completely blank documents.
What page was that? Real quick, Renee.
It's well, the first
I'm on
one,
exhibit 9, but you said
exhibit
it was
9, go to the lease and go down to the very
very
end and go back.
I see like the radon disclosure. I see the
there's 2 little lines and the little circles.
It's
Just
third to the last page. Yeah.
Okay.
And then there's initials, and then there are signatures and dates on the next
yeah,
page.
I see like a mark. Yeah, there's a
Yeah, it
mark
doesn't
on
look like a
number
check
2.
mark to me.
It's not a check mark, but it's a mark.
line.
It's like it's an exclamation point in there.
Yeah, that's what it looks like to me, is an exclamation point.
Right. So they need to do a better job of filling that in or doing a check mark, but there is a line and they are initialed and they are signed.
Renee, on page 65 of the PDF, are you seeing a signature on those? Because like I said, interesting, because mine are completely blank in that exhibit I just opened up that we sent to you. So
No,
there's got to be a
there's 3
PDF
signatures on that page.
Yeah, I appreciate you saying that, because I'm looking at the same exact exhibit, same exact page number, and there are no signatures. And so it is possible it's something weird with our Adobe at the state. There is nothing there. So
yeah, there's definitely signatures
signatures there.
There's signatures on lead-based paint, there's signatures on the Colorado radon, and then at the end there's the certificates as well.
But if I'm wondering if those are really actual check marks, because if you go up a couple pages from that, go up 1, 2 pages from that, and look at the check marks that they have in the lead-based paint.
I think they are, because if it weren't,
lines, they just need to be told they need better ones, but it is there, it is initialed, it is signed.
Yeah, because if it weren't, they all would have exclamation points in them.
Yeah, so I think
there's something that was there.
As far as reducing the fine, I would agree in this case, the fine should be changed because we do have the radon disclosures and they are signed. So if we want to be consistent with the one we just did, we would drop it down to 2,500.
Commissioners, just if I may provide more information on my end, and we are 2 different offices, I also don't see any check marks. So maybe Sarah is correct. Maybe it's something with state software, because I don't see anything, like no check marks, no exclamation, nothing.
That little itty mark, you don't see it either?
No.
We need
no
to hit the timeout button and allow Sarah to go back and review this in more detail before making a judgment or a decision.
Well, they're there, so I think we just reduce the fine.
Yeah, I mean, if you guys see the signatures there, I think it is a software issue on our end. That's fine, then you can remove that violation. And then reduce the fine as you see needed.
Okay, so if we take the radon thing out of the picture, then
the only thing
the only thing we've got is the price sheet, right?
Yeah, which I mean, I don't think should be a $2,500 fine, because
the problem is they were told
they provided it. They were told differently, but is that $2,500?
I think $1,000 fine and you don't do it, there's a problem. So on one hand, I think there's an issue.
I think we fine. I think $1,000 fine though. I mean, $2,500 is a lot for something that was provided, but just not in the way that we told them to. And they have corrected that. Is that right? I believe Meredith said that they corrected that moving forward.
Yeah, price sheet moving forward, there is like I said, there's a gap in time that's an easy follow-up that they can just make sure those tenants and owners have the updated sheet. But moving forward, I feel confident that they've provided evidence of full compliance moving forward. And thank you for looking up the radon disclosures, Renee, because we have something going on over here we'll look into.
Okay, so we'll reduce the fine to $1,000. Is that what we're saying?
Yes.
Yes.
Okay, you want to make a motion then? Or
Okay.
well, actually, first, are they still on probation then or not?
And is it still final agency?
And is it a second audit? I mean, they didn't have the pricing done here, but you're saying it's done now. So this is kind of a weird thing because we're giving them a fine, $1,000, because when you looked at it, the pricing wasn't done now. So do we take out the probation in the second audit?
I think we
would
leave
second
the,
audit.
we leave the second audit, I think.
Uh-huh. And
Are we taking out the probation though?
well, we put it on there the first time. I would leave it alone. I would leave it because that's what we said the first time.
Until
so
the second audit.
We're just gonna change it to the fine of $1,000. Okay, someone want to make a motion?
And just to clarify, that still would be under final agency order, correct? I just want to make sure.
Yeah,
That's a question for staff.
why?
I mean, I would assume, I just want to make sure that that doesn't change anything.
I'm sorry, you said that was a question for me?
Yes, it's appropriate to keep that under final agency order, correct? Even us reducing the fine.
Absolutely. Yep,
Okay.
do that.
Okay,
Yep.
thank you.
All right, someone want to make a motion?
Okay, motion to accept disciplinary recommendations with the following adjustment. Reduce the fine to $1,000. I guess that's it, and that's it.
Okay, do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes.
I do have a question about something though. When we were talking about forms earlier today and all that, do we want to add that to something that we want to talk about on these forms for this, for their, what's required for these? How we're telling them that they need to have this price sheet, it's part of what they have to provide. Do we want to discuss that later? Overall?
Well, Renee, I think maybe what she's
Normally, all
mentioning-
pricing is disclosed in writing. There's been some debate over the years whether you can change it with an email or put it on a website. I don't know. Do we want to get into that discussion?
Maybe that
Speak
could be
for
a
somebody to
topic.
get fined if there's debate about it, we should put it to rest as to if it is allowed or not allowed. Because I'm questioning it myself. I'm wondering.
Okay, so are you wanting to add that as an agenda item?
I
for
think
the
we
next
add it as an agenda
meeting?
item.
Yeah, I would add that. It's something I think we should probably talk so that we can kind of give what our opinion is on it.
And you mentioned, Renee, to Bernadette's point, that you had recommended a little bit more guidance. I don't know if it was in coursework or if it was in forms on property management. You said that earlier.
Well, I mentioned the property management license that is
A license. Okay.
that
Gotcha.
should be, I would like to see done that has classes, but that's been
Okay.
shut down for years. But it would be
Gotcha.
good to have a property management license because if we're requiring classes in a lot of these things, it might solve some of these problems in some of these cases.
Yeah.
Yeah, it seems like there's a lot of property management. There's a lot to that. That's its own, I
Yep.
think, its own beast on its own.
Okay, so we're asking Marcia to add an agenda item dealing with whether we can have price lists online, whether it has to go in person or be given to a person.
Yeah. It doesn't hurt at least to talk and see what we think about it.
Okay. All right. Not sure if Marcia's listening, but okay.
It will be on your next agenda.
Okay, thanks. All right, so I guess we can move on to O.
On to O? Okay. So matter O is complaint number X 2025-155. This audit was opened based on a stipulation signed on June 14th, 2025. The broker was to provide compliant reconciliations without negative ledger balances. a broker's ledger so that the auditor could trace the source and timing of broker funds listed on a separate liability ledger in each account. Additionally, owner-tenant statements were to indicate no negative balances during the month. It appears each of the areas of concern from the past audit remain out of compliance. Possible violation is 1210-2171M. Disciplinary recommendation is a final agency order, public censure, a fine of $2,500, and an audit within 6 months. And Auditor Meredith's here to answer any questions you have.
I'm sorry, did you say there is already that second audit, right, on this one?
Correct. This was the first of 2 audits.
Okay. I mean, again, I said I would have a theme today. With those that have been trying to comply. We've had some that weren't trying to comply. This one, I was just trying to see.
This one's not trying to comply, so I think we leave it alone as it is.
This one, I'm
There's
trying to
still
find my
lots of
notes.
issues.
Let's see. Sorry, hang on.
They didn't provide the journal, didn't provide the ledger. We're doing accrual, not cash. We have all sorts of issues. This one just needs to stay how it is.
Let's see.
I agree on this one. She was still out of compliance. She provided some statements, but again, yeah, Renee, no journals, no ledgers. She's paying her assistant out of the rent trust account. We
Yeah,
can't verify anything because she just can't get us the information to verify. I mean, I believe she desires to be compliant, but she can't explain or correct any of the accounting to comply at this point.
Right. So I think we leave this as it is. So someone want to make a motion?
I move to accept staff recommendations.
We have a second.
I'll second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Okay, motion passes.
Right. Investigative matter P is complaint number X 2025-156. The respondent signed a stipulation agreement which required her to submit an explanation and documentation for the previous negative ledger balances, 2 months of compliant reconciliations, and owner statements that correlate to ledgers. Based on the documents submitted within this first audit, it appeared that the respondent failed to meet the expectations in the stipulation agreement. An additional final notice to comply was provided, and the subsequent submissions indicated ongoing concerns with the accounting. The respondent provided evidence that she has tried to find an accountant to be able to help her, but has been unable to do so. Possible violations are 1210-217-1H, 1210-217-1M, an additional violation of 1210-217-1M, and Rule 5.14. Disciplinary recommendation is a final agency order, public censure, a fine of $7,500, and coursework in trust accounts. And Auditor Meredith can answer any questions you may have.
So why is this fine $7,500?
You know, I believe that this was based on the original fine amount for the stipulation. And I can get to that here. Second.
But isn't this fine in addition to the original stip? Because the original stip was one on its own and it had a fine, and this will be another one with its own fine, right?
Correct. Yeah. Yes. It's just, you know, they received an initial fine for non-compliance, and then now we're moving on to a new case. And I would say that generally in investigations and typically with these, they've had a previous fine that's still not fixed, it would increase. But again, it's completely up to your guys' discretion.
My notes on this one was, well, I guess I just wanted to verify, this was one of 2 audits.
I believe that is true. Yes.
Okay.
I don't see a second one.
Because I didn't see it, but I was like confused when I was going through it, if there was 1 or 2 audits. I guess I got to go back to that stipulation. My notes on this one was that there's there was a statement that said there were no outstanding concerns, but the concerns that are there continue to center around the reconciliations. So I want to verify that that I'm interpreting that properly, that really it's the reconciliations that are the issue, and this particular individual is having trouble reconciling, and she's hired bookkeepers, and even the bookkeepers can't figure it out. So again, I guess let me confirm that is if I'm interpreting that correctly.
So if the primary and major source here is the reconciliations, and yes, this particular broker, and I did ask her to provide evidence of contacting accountants, and she has made a valiant effort to try to get help. But despite those efforts, there really hasn't been any movement in terms of compliance on these reconciliations.
So do we see a path to her being in compliance if other bookkeepers aren't even able to fix it?
That would be up to her. I mean, she's required to get me compliant, get the auditors and you to be able to present to you commissioners compliant reconciliation. She's going to have to, figure out the best route forward. Sometimes that's starting from scratch on the software, but that's ultimately going to have to be her and her team. But she is required to get compliant reconciliations. We don't give guidance in terms of specifically how to do that because, each software program is different, and then whatever created this problem in the first place is not something that we have the ability to track.
Okay. Now, but to your point, and this is just me not knowing, and this also, Renee, you could probably answer this question. So an individual in this situation can get new software, kind of start from scratch and on a clean slate. That's possible.
Well, and she did start a new bookkeeping system, correct? I mean, that's what I have in my notes. They updated their bank accounts. They changed bookkeeping systems. She's been trying to retain a new accounting firm, but do we know why they're just telling her no? Because they don't think they can get it done?
They're just letters saying, I'm too busy. It's not really, on one hand, her original fine was $2,500. I don't think it's fair to fine her $7,500 right now. I would like to see that reduced down to $2,500. On the other hand, anybody can get a letter saying, oh, I'm too busy to help you. So I, kind of don't buy that one, but I do think the fine should be reduced down. I don't know why we went from $2,500 to $7,500.
And then we'll continue to do another audit.
Yeah. I think we need another audit if she's can't get into compliance with this. I would make sure we have another audit scheduled. I mean, this is.
What software did she switch to? I'm looking for it. I don't remember. Did she switch to AppFolio? Did it say?
I don't recall, Commissioner, which software. There's a combination of software switches, and then if the new software program adopted previous errors, it's like the dent in the cake pan, right? If something was wrong years ago and it just keeps compiling, even if you switch to the new software.
I do have an answer for that, Renee.
It looks like she went
it was one of the areas I highlighted. It says she went from
rent manager to Rentvine.
To Rentvine, yeah.
Okay, well, Rentvine has people on staff that should be able to help her. So I would say we drop the fine to $2,500, and she it says she's worked with them. After doing this, I'm attaching new reconciliations that show no negative balances, but it says there were negative balances.
It says she was forcing the balances or doing like balance forward or journal entries to get it done, but it didn't show where the missing money was for that. And so that was kind of the issue. It just wasn't being done correctly.
Okay, but it's a $500 balance to something. She can get that fixed, and then there's not much of an issue. So is that all there is a $500 negative balance? That's the only thing I see on the report. Is there more?
So, if I don't have this, what I remember from this and looking at it last week, is there were other issues with Rule 5.14 and how the documents, what she provided. I don't believe it's just the $500, but because there were struggles with giving me each component of the reconciliation depending on when she sent them in.
Okay, so I think we should drop the fine to $2,500. She's got another audit that has to be done. Right? Yeah, second audit. No, wait, am I in the wrong one?
I didn't see a second audit on there.
Let me see.
I can verify that as well. I may have made an error.
Am I quite just real quick? She mentions that she reached out to 8 bookkeeping companies. Now it's unlikely that like 1 or 2 maybe say no, right? You can manipulate that potentially, but 8, I mean, that's a lot to.
Unless she waited to do it all at the last minute and was like, "Hey, I need this crash done
Yeah, which
now,"
she
and then
maybe
maybe
did
all
because
8.
she was
could.
she was in the middle of an audit. But I'm just saying some consideration to that, some consideration to the fact that she has been apparently trying. I saw the same thing that you guys saw, that it only mentioned the $500 negative balance. And there it said it was a property that it was a security deposit item. And it was an old owner or something like that. So there is an issue with this $500 that may be the main culprit of this whole thing. And I agree. I don't know. I still think a little bit of a lower fine until her next audit.
And I can confirm the original step called for 2 audits. So this was the first of those 2.
Okay. It did. Okay. So I think like, I don't know, I would say go back to like the other, do that $1,000 and then raise it.
I say 2,500. That's what we've been doing, is 2,500. I think we should do 2,500 and then second audit.
I second that, Renee.
So, all right, Autumn, you want to make a motion?
Sure. I move to accept staff recommendation with the modification and deduction from the fine from 7,500 to 2,500. And as part of the original step, another audit will follow. I don't know if we had a duration, 30 days, 90 days.
Let's say second audit within what, 3 months? Isn't that what we normally do?
Yeah.
Okay. With second audit within 90 days.
Okay. All right, is there a second?
I'll second that.
Okay. Any further discussion? All right, all those in favor?
Aye.
Aye. Any opposed? Motion passes.
All right, investigative matter Q is complaint number X 2025-160. A routine audit was opened on the broker, who during the course of the audit made numerous corrections. This included changing his process to ensure that the broker's disclosure to tenant is provided in accordance with Rule 6.5, updating his trust accounts to fiduciary accounts, and ensuring the reconciliations comply with Rule 5.14. The broker also affirmed that all advances to property owners will be made in accordance with Rules 5.10, and all markups profits will be disclosed in advance in accordance with Rule 5.17. Possible violations include 1210-217-1I, 1210-217-1M, Rule 5.10, 5.14, 6.5, and 5.17. Disciplinary recommendation is a diversion and a fine of $500. And Auditor Meredith is here to answer any questions you may have.
You know, I just wrote down on this one that it sounded like the respondent was responsive and proactive. Did an excellent job correcting the issues, and I appreciated that.
Yep. Can we motion?
All right.
Yeah.
Motion to accept staff recommendation.
We have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
Take care, commissioners.
Okay, matter R is complaint number 2025-768. The complainant was the buyer of a large parcel of vacant land. The respondent was the transaction broker working with both the buyer and the seller on the transaction. The respondent had worked with the seller in approximately 20 previous transaction sides, including when the current seller originally bought the parcel. In the original transaction, the respondent clearly outlined in the contract to buy and sell that there was no legal deeded access or recorded easement to the property. In the subsequent transaction, the complainant's purchase, the respondent did not include the same plain language disclosure in the CBS, although he understood that there had been no change in the deeded legal access or easement to the property. The title commitment noted a lack of access. However, the complainant alleged that the respondent had assured him an owner affidavit would suffice. After closing, the complainant became aware that the access was not as he understood it. The respondent referenced a grazing lease that provided reduced property tax rates as an attractive feature of the property. After closing, the complainant learned that no lease existed. Possible violations are 1210-217-1B, 1210-217-1M, 1210-407-2B, 1210-407-2B6, 1210-407-1, Rule 5.14 and Rule 6.5. Disciplinary recommendation includes a final agency order, public censure, a fine of $10,000, coursework in ethics, brokerage relationships, and contracts. And I apologize, there are additional violations below of 1210-217-1Q, 1210-217-1C, and 1210-407-2B2. And Investigator Hardy's here to answer any questions you may have.
There was a lot on this one, I thought.
Yep. The biggest concern for me was that because he sold that parcel before and had included very specific language about access, it seemed very intentional that that wasn't included when he was the listing agent.
Agree.
So and there are 1, 2, 3, 4, 5, 6, 7, 8 violations.
Yeah.
I don't know. I mean, what I've seen in the past, this kind of teeters towards revocation in some instances that we've seen, similar scenarios. Not saying that we go that way or not, but I just wonder if that fine is sufficient. I just wonder if the discipline is sufficient based on it's pretty clear that he knew.
Well, and the respondent is familiar with this type of listing. It's not like this is the first one that he's listed. There's a lot to this, I thought.
Well, he sold this one to the buyer who became the seller, and he just all these things were disclosed in that contract, but then when he becomes a listing agent on this, he doesn't disclose any of this. And in fact, kind of gave the impression that everything is okay. And unfortunately, the individual that was the buyer is harmed severely. I mean, they're stuck trying to sell a property that they purchased for what, $650 or something like that with
No, they
access.
ended up purchasing it for like $250. I think that was the listing.
No, that was the first one. I'm talking about the second buyer.
630.
It was 600 and something.
630.
Yeah. I think they broke it up in pieces.
No, when the original. No, it was 250 is what
230 and then 630.
Yeah. So the
400,000.
The buyer that this person represented bought it for 230. But then they listed it for 630.
A year later.
And so that person that paid the 630 was harmed because they can't even access the property. And while it was mentioned in title, they're kind of using that, but I guess my issue is that this individual knew based on how they wrote the contract when they were the buyer's agent, they were well aware that there were access concerns, and he was sure to protect his buyer. But when it came to selling it, he didn't provide that same level of care in terms of disclosure. And I mean, that's the problem I have with this one. So I'm interested to see what everybody else thinks, if the discipline is sufficient or not. But
and he ended up becoming a transaction. He ended up representing both sides, I guess. Did both sides of this transaction. It wasn't just one.
Right.
So Erica, I agree with you. I felt the fine was a little light, and I also felt like we should be discussing some type of probation or suspension.
Yeah, I have several notes on this one. I think it's very light for what happened. I've got a lot of notes on here, but I'll highlight just a couple of them. One, I don't know if you guys took a look at, I'm sure you did, his advertising, but he had a beautiful brochure on there. On page 3 of the descriptive text, paragraph 2 starts off by stating year-round enjoyment is guaranteed with easy access provided by a gravel private road and interior dirt roads.
I did see that.
Yeah, I read that as I have access on my own private road.
Mm-hmm.
And there's nothing in the promotional material, unless I misread it, speaking to any type of limitations on accessibility. So that's a hurdle in my mind as far as misrepresentation. If you follow it up with an owner's affidavit and title work that says otherwise, I'm kind of curious about that. I don't think these buyers had access. And he clearly knew that. It was not put in that contract at all. I think that was a real problem. The other thing that I think is highly problematic was being a transaction broker in this case. He had represented this seller 20 times. It says, the respondent says 6 to 7. The seller says 24 times over 13 or 14 years. So there's a couple, several things with that one, but I mean, let's say you could do that. Let's say you could do that. You have to have everyone sign this before you move forward. The respondent had the seller sign it after he signed the contract to buy and sell. I mean, that's just inappropriate timing in itself on that one. But he should have stayed a seller's agent and just did the deal with the buyer remaining as a customer. You cannot, in my opinion, be a TB in this type of a transaction.
And I think we saw that in how it played out.
Absolutely.
So do we know, has this case gone any further legally? Has it been referred anywhere else, or is it in court? Do we know if something else is happening with this?
It's my understanding that it has not, that there's not a civil action related to this.
Because did it ever get sold again?
No, the complainant has it, is trying to list it now.
Yeah. Okay.
Do we know what he's trying to list it for?
I don't. It hasn't. The complainant stated that he wanted to be able to advertise it correctly and is still trying to sort out what that means for him and what he can say about access. And so I don't think it's actually listed yet.
So he might end up taking a monetary loss on this.
Right. Then he could go to court or something. But so what do you think? What do you guys think should be the recommendation then? Increase the fine to what, or what other changes do you think should be made?
I mean, and I'm not big on pushing revocation, right? But because all of the evidence shows that he had to know this.
He did.
That last transaction says it all. Like, you knew because you represented your buyer when he bought it. So you knew that there's access, and you intentionally didn't tell this person who now has a huge, huge, huge loss. I don't know. I agree. I mean, we need to at least consider revocation, probation, suspension, something along those lines.
The only thing I can say on the other side of that is he did give the owner's affidavit form. So that was received and it was disclosed in title. I just think that it should have gone further, like a lot further.
Mm-hmm.
Yeah.
Particularly when you're describing in your advertising guaranteed easy access provided by gravel, private road, and interior dirt roads. And then tossing over here, but here's an owner's affidavit, which may or may not be sufficient, may have to go to court to resolve. And having it so clearly defined in the purchase contract previously and not defined at all in the one where you're trying to be a TB.
So it's completely deceptive on purpose.
Yeah,
And
we definitely should add that rule, the advertising rule, which is, I have to go find it.
Yeah, and if this guy, I mean, it's not even, I almost wish that we would have seen this after the guy tries to figure out how much he can
Sanders?
sell it for.
Yes.
I think you're speaking about 217(1)(a), knowingly making any misrepresentation or knowingly making use of any false or misleading advertising. Is that the violation that you were thinking
Yeah,
about?
and there's a rule too. 6 point, is it 3? No. Yeah, there's a rule as well on that, isn't there? 6.
Well, the statute, we can add that to 217(1)(a).
Yeah, definitely that. 6.10 is the rule. With that, Irina, with that,
I'm looking at the rule right now.
I just want to make sure
statute
that's
for
right.
sure, but I'm just looking at the rule. So give me a second.
Okay. And while she's doing that, I mean, do we agree on a little bit more license discipline, meaning revocation, probation, suspension, or are we leaning towards a higher fine? I'd like to get everyone's take on that.
Well, I definitely think a higher fine for sure.
Yeah, I thought both.
Because we're looking at, yeah, and I think the other one is too, like revocation, suspension. There's got to be something more with this.
I mean, how do you guys feel about increasing the fine to 15,000? And then we can start the conversation with probation or suspension for 6 months. I don't know if we feel the need to jump right to revocation. That's something that we can certainly unpack.
Probation doesn't really do it much.
Okay, noted.
Yeah, I don't think
suspension
probation
then.
is either.
I think that, yeah, probation's a better tool for other situations. Probably a suspension would be
6 months.
most appropriate. I don't know if it's 3 months, I don't know if it's 6 months. But this does take in consideration what you brought up, Erica, with, you know, he did provide something, but I don't think it was sufficient, right? But so maybe not just dive into revocation. But what were your thoughts? And did you have any notes on whether you
I
feel
didn't write down anything for what the fine should be. I feel like it should be more. Because I think that this buyer is going to be impacted tremendously.
I do too.
And we don't know what that outcome is going to be yet.
Let's do the fine of 15 and then suspension. I think 6 months is a long time. Do you want to do 3 months?
I would lean towards 6 months and let them, I think it's going to take a while to get through all what's going to happen with this. So I would lean towards the 6 months.
Okay.
I mean, I think he knew.
Okay, I'm gonna make a motion then to accept staff recommendation to increase the fine to 15,000 and add suspension at 6 months.
6 months is a long time.
Well, and hang on, because we have to add
That
rules, and
1210,
Irina's still looking at that.
17(1)(a), I think.
17(1)(a), for.
And then
she's
we're
still
looking at
looking
the
at the
rule.
rule 6.10.
And 6.10 Part C is applicable if you wish to add this one.
Will you read that real quick, Irina?
Yeah, Rule 6.10 Part C.
Okay.
So we need to add that in the motion. Okay, but we're not really on the same page with the
Yeah, we doing
the
3 months
to
or
6
6
months.
months?
So let's just poll everybody real quick. Renee, you said 3.
Yeah.
Autumn, you said 6. Erica,
I do 6.
Bernadette,
6.
and I was kind of thinking I could kind of go either way, but but I mean I would be okay with because the other thing 3, the downside to 3 is in this market things, and especially if assuming that this individual does a lot of rural stuff, it's going to be longer time, so that 3 months might not really make a big difference.
And
So-
Irina, I apologize. It was 6.10A. What was the other one?
No, 6.10 C.
like
C.
Charlie.
Correct.
C's and cat.
And what was the other one?
And the other one was
1A.
I'm sorry. There were a couple people talking over each other. I didn't quite catch that. Say that one more time.
217 1A. 12-10-217 1A.
Okay, got it. All right. So move to accept staff recommendation with the modifications of adding 6.10C and 171A, modifying the fine from 10,000 to 15,000 and adding a 6-month suspension.
Okay, do we have a second?
Second.
Although, any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes.
Okay. So investigative matter S is complaint number 2025-2018. On July 11th, 2025, respondent entered a plea of guilty to vehicular assault DUI, a class 4 felony. Respondent was also sentenced on July 11th, 2025. Respondent did notify the division of the conviction. The division was notified of the conviction via a CBI report. Respondent accepted a 3-year deferred sentence and 48 hours of community service. Respondent also agreed to pay court costs and fines in the amount of $2,894.50. The referral says that the respondent has paid $2,235 of his court costs. I have an update today that his court costs have been completely paid, and he has completed 12 hours of community service. Possible violations are 12-10-217-1M, 12-10-217-1N, 12-10-217-1P, and Rule 6.23. And the disciplinary recommendation is a diversion, fine of $500, and probation concurrent with the criminal probation. Investigator Denise Wright is here to answer any questions.
No questions? Someone want to make a motion?
Motion to accept staff disciplinary recommendation.
We have a second?
Aye. Me.
Any further discussion? Right, all those in favor?
Aye.
Any opposed? Okay, motion passes.
All right, so matter T is complaint number 2025-47. Complainant, a licensed real estate broker, explained respondent represented the buyers of complainant's listing, property 1. Complainant stated that the purchase of property 1 was contingent on the buyers selling their property, property 2. Complainant alleged that the contract respondent submitted on property 1 had a closing date that the buyers could not perform because their closing date to sell property 2 was after the contracted property 1 closing date. Complainant also alleged that respondent misled him by telling him that the buyers of property 2 were already through their inspection when that was not true. Possible violations include 12-10-217-1B, 12-10-217-1C, 12-10-217-1M, 12-10-217-1Q, 1210-405-1B and Rule 6.2. Disciplinary recommendation is a final agency order, a fine of $5,000, coursework and contract, ethics, and brokerage relationships. And Investigator Denise Wright is here to answer any questions you may have.
Any discussion or someone want to make a motion?
I kind of don't, I don't know. I think it's a little stiff for it. I don't think that she did this on purpose. Just reading through everything. I mean, they were putting money down. I don't know. I think it's a little stiff.
I actually thought it was appropriate because this agent lied through the whole entire process. It was just one after, which is misrepresentation after misrepresentation after misrepresentation. It started with the respondent saying that they're not doing an inspection, and then it went to, there were so many. It was about 4 or 5 lies back to back. The closing that to me kind of fell into competency, having a closing date after, but then when you really read the details of that, she was not honest with both sides about it. So I think it's appropriate. I think the fine is appropriate.
I felt the same.
I agree. I wrote down, competency, misleading. She was not forthcoming on dates, and lucky they both closed.
Mm-hmm.
Mm-hmm.
I mean, even there was a text message, I think it was a text message, but where she's telling I believe it was the buyers purchasing her listing that, oh no, the date, this is the date. Oh, it's definitely the date. And it wasn't the date. There was proof that it wasn't the date. So yeah, I think this is appropriate.
So someone want to make a motion?
I'll motion to accept. Oh, go ahead.
No, you go ahead, Autumn.
Okay. I'll motion
You
to
got
accept
it.
that recommendation.
Okay, do we have a second?
Yeah, I'll second that.
All right, any further discussion? All those in favor?
Aye.
Aye.
I'll go
Any
with it.
opposed? Motion passes.
Right, Commission Matter U is complaint number 2025-2033. On July 23rd, 2025, the respondent signed a final agency order agreeing to the Board of Real Estate appraisal findings and discipline in 2 investigations. The respondent did not provide any of the information requested. In his written response, the respondent claims that CREC does not have jurisdiction over the Board of Real Estate Appraisers matter, as it was not the result of a real estate brokerage activity, and 2, the case is still going through the legal process. Possible violations are 1210-217-1AA and 1210-217-1M. Also Rule 6.23. Disciplinary recommendation is a final agency order, a fine of $500, and a high level of supervision on the license for an additional 3 years. And Investigator Levy is here to answer any questions you may have.
Did I read this right? Make sure I want to understand this. His appraisal license was revoked on Friday, 10/31/25. And then CREC opened an investigation on him on the following Monday. Is that right?
Well, it looks like
to report it. So we're telling him that he didn't report that.
no, we didn't tell him that, did we?
No. Oh, you're saying Rule 6.23?
Yeah, 623.
Yeah. For not reporting. But that was like a Friday to a Monday.
Yeah, that's pretty quick.
That's, I mean,
Well,
we don't
but-
know what time that happened. And then by Monday, we're like, you didn't report it, but we already automatically opened an investigation with them. And
No, he signed the FAO for the real estate appraisers on July 23rd, 2025. So he didn't report that.
that's what it's for. It's for that one.
Yeah, that's
That's
the
one
day
he
it was
didn't report.
signed.
Right. Yeah, sorry, I was trying to look it up here.
So that's why it's 6/23.
Yeah. and to be
Okay.
clear, it's the same matter, but he entered into the stipulation in July and some of the terms didn't go into, there was a delay of enforcement, but he did enter into it into July. It's the same action.
Okay.
So someone want to make a motion?
Well, motion to accept staff recommendation.
We have a second.
Second.
I'll second. Oh,
All right, any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
I just lost that last referral, so let me grab it quick. Okay, so investigative matter V is complaint number 2025-395. The respondent was the buyer agent for a complainant in a transaction involving the purchase of a condominium in Winter Park. The allegations are as follows. The respondent provided the complainant with mortgage advice, which is beyond her area of expertise. The respondent performed an inspection of the subject property for the buyer, which was beyond her area of expertise. The respondent revealed to the seller's agent confidential information about the complainant without the complainant's permission, and the respondent provided the complainant with the garage code, and the complainant then accessed the garage unaccompanied by the respondent or another licensed broker. Possible violations are 1210-217-1Q, 1210-217-1M, 1210-405-1B, 1210-405-1V, 1210-405-2D, and Rule 6.16. Disciplinary recommendation is a diversion, a fine of $1,500, and coursework in brokerage relationships. Investigator Rakay is not here today, but I can try and answer any questions you might have.
This one I just noted that discipline seemed fair.
About the same.
All right, well, motion to accept staff recommendation.
I'll second.
Okay, any further discussion? All right, all those in favor?
Aye.
Aye.
Any opposed? Motion passes.
Okay, your next agenda item is investigative matter W. This is complaint or audit number X 2025-144. On August 21st, 2025, the respondent was selected for a routine audit. The audit notification letter was sent to the email address of the respondent file with the division. The response was not received, so a final notice was emailed to the respondent. Additionally, copies of both the audit notification letter and final notice were sent through certified mail to both mail addresses, the respondent file with the division. The division did receive a certified mail receipt indicating that one of the letters was received. However, this address is likely no longer associated with the respondent because it belongs to the respondent's previous brokerage firm. The respondent's real estate license was eligible for renewal beginning November 1st, 2025 and expired December 31st, 2025. Possible violations include 12-10-2171M, Rule 6.24, and Rule 6.25. Recommended disciplinary action was diversion, $500 fine, and a suspension until the audit has been completed. With this respondent having an expired license, I don't now thinking through this, I don't know if that disciplinary action is allowed, or maybe in regards to the suspension until the audit is completed, maybe it needs to be something like a audit at any time of like license reinstatement or something in that regards. I don't know if Irina or Penny can speak up to that, with this respondent now currently having an expired license.
Yeah, that makes sense. Is Penny on?
I'm here.
Would I agree with that. If we want to prevent this person from being able to get a license without paying to reinstate their license without paying this fine, but how do we do that properly?
So I think Eddie had a good suggestion in terms of we could maybe make the terms, the audit to be done within 30 days of reactivation or something like that. I mean, you'd want something to audit, you'd want something to look at. I don't know whether they've just let it, sometimes people just let it go expired to sort of avoid this process, and then they, come back quickly. I don't know what this person's, whether their intention is to renew or not. But
we've had zero contact with this individual. The best I've been able to kind of discover in some research, I think they moved out of state. They no longer reside in Colorado. I think they work for a different company out of state, but I have not been able to make any sort of contact with them. The auditor who originally opened up this audit was also not able to get in touch with them. And so now with an expired license, there's no license to suspend. And so I think that some sort of audit at reactivation or reinstatement, or it would be appropriate in the event they were to ever reapply. But at this point, we don't know.
I just so I have a better understanding of that process. In the event this individual did come back, and let's just say it's, a few years later, 4 years later, 4 or 5 years later, and they came back to apply for a license. When you say audit, what are we auditing? Because chances are there's no files in that first 30 days. So are we auditing previous files, which after a certain amount of time, they're not required to keep? So I just don't know if the audit is helpful. I think, but I don't know if we're able to flag the license at a time of relicensure and say, hey, you have this outstanding fine. You can't reapply until this has been paid. Is that something that we can do?
If I was just going to comment, if they were to reapply within the reinstatement period, which is in the next 3 years from now, I guess there is the possibility that they had some transactions within their 4-year record retention period. Now, that said, it's very likely they didn't have any transactions in the last 12 months, which is what we would normally audit when we open up an audit.
But they would still have to pay the fine. Or no?
Well, so all of these things, and like this decision, if they sign a stipulation with me, if they do respond and sign a stipulation saying that upon reactivation, they agree to pay this fine. If they don't, then the case has to be litigated. So then we would go through that process. I think if this is what the commission wanted to seek in this circumstance, then I could work with them, if we can get in touch with them, to say that, this is what the action is, but we'll stay this pending a reapplication or a reinstatement of your license. It's hard to say whether we'll have any contact or not.
Do we know if the respondent has applied for a license in the new state?
I could not find any information online. In the company that I believe that this person may be working for does not appear to be a real estate brokerage. It does not appear that they're doing real estate activity in the state that they may be living in, if my online research was even accurate.
Those are all great questions, guys.
Okay, so does someone want to make a motion changing
removing the suspension and changing it to an audit done within 30 days of reactivation.
Yeah, I can do that. I make a movement to accept staff recommendation with the modification of suspension since the license is already lapsed. And oh shoot, what was it?
And have an audit done within 30 days of reactivation.
Thank you. And complete an audit within 30 days of reactivation.
Okay, do we have a second?
Second.
Okay, any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
I forgot to say aye, but I want to put it on the record.
Okay. I want to get to it here. Investigative matter X is complaint number 2025-1864. Excuse me. On May 21st, 2025, the respondent self-reported to the state of Washington that his real estate license had been disciplined in multiple states. Wisconsin suspended his broker and business entity licenses for 30 days on February 1st, 2024 for inadequate inspection and inaccurate listing information. North Carolina issued a stayed 9-month suspension on October 16th, 2024, and Maine imposed a fine on November 21st, 2024, both for failure to timely report the Wisconsin and Colorado actions. Kansas revoked the respondent's broker license on January 14th, 2025 for failure to timely report actions taken by Colorado, Wisconsin, North Carolina, and Maine. Utah suspended his principal broker license for 30 days and imposed probation on May 9th, 2025 based on the same conduct. The respondent failed to report each disciplinary action to the department within 20 days as required. Section 1210-217-1X, license discipline in another jurisdiction, and Rule 6.23 requires written self-reporting of out-of-state disciplinary actions within 30 calendar days. The Commission's guidance confirms this requirement. The state of Washington agreed that the order became final on September 17th, 2025, and was reported to the Colorado Division of Real Estate on October 8th, 2025. Possible violations include 1210-217-1X, 1210-217-1M, Rule 6.23. And on this one, there is no recommendation. And Investigator Wentz is here to answer any questions you may have.
So this one is tied to the next two.
Correct.
So should we go ahead and look at them all together?
Yeah, absolutely. Do you want to move on to the next one?
I was thinking the same thing.
Yep, same.
Okay, sounds good.
So it's the same stuff. You don't have to read it again.
It's the same stuff. This is complaint number 2025-2134. Possible violations on this are 1210-217-1X, 1210-217-1M, and 6.23. And then matter Z is complaint number 2025-2390. Possible violation 1210-217-1X, 1210-217-1M, Rule 6.23. And again, no disciplinary recommendation.
Okay, so this is kind of like this vicious circle because you
Yeah.
don't report here, you don't report there, then they do this, then that doesn't get reported. It's like this, it just goes round and round and round and round. So I don't know, can we lump these all together? Do we actually have to give a recommendation for each one? Can we do them together?
Yes, I think you can do them together. You can have one recommendation for all three complete numbers.
Let me make sure I'm understanding this and I'm looking back. to make sure my notes are accurate. In my notes, I am under the impression that he did self-report to Colorado all of these other new and all these other new issues with all the different states. He self-reported that discipline to Colorado within 30 days.
That is correct, ma'am.
Okay. So, and then this stemmed from a Colorado complaint.
That is correct.
Okay. So I just want to make sure I noted that right. What I had in my notes, because it's just more of a reporting thing and he reported to us timely, I don't think that we proceed with discipline because the discipline that he received in the other states started from the discipline in Colorado, to Renee's point. So it's just a cycle. So it doesn't seem to me that we disciplined for something that was disciplined already. We already did our part. We disciplined as a result of that. He was disciplined in multiple other states and he reported that discipline timely. So from my perspective, I don't think that we need to offer more discipline on top of it because we've already disciplined. Unless he had not reported timely, then that would have been another circumstance. But because he timely reported the discipline that he received in all the other states, I don't think we continue to discipline on something that started here in the first place.
And if I can add one more thing just really quickly, we have received 2 additional complaints from other states for the exact same thing. So again, if it is your decision maybe not to continue to discipline on these, perhaps some guidance for investigations that, if it's just another state reporting this, potentially we do not need to open the complaint if that's, where you're heading with that. So.
Yeah,
I think
somewhere we need to stop it.
Yeah.
It's got to stop somewhere. I mean, if it's all new charges, if it's like something new somewhere else, fine. But we got to stop.
Are these new charges? Because I thought it was all the same recycling charge. Am I missing? Did I miss that? Which is possible. It's all stemming from the same charge.
Yeah.
Yeah.
Just other states coming back.
Right.
Well, he's licensed in multiple states, so it's all based off of what we discipline that we handed down.
Right. So I don't think we keep disciplining something we already disciplined. And then he's received discipline in those prospective states and he reported that to us. So I think it just stops there.
So do we do a dismissal with letter of concern or some other letter?
I don't think we do anything.
Do we
think there's even a letter of concern because we're just kind of like noted exactly what we need. And then to Sarah's point, then they have some guidance as to how to move forward when something like this happens, because they could have 50 states coming back at them. And this would come again and again to us, and we're just going to say noted.
Yeah.
I don't know. Is that what you were thinking, Sarah?
It was. Melissa, did you have a...
Yep. So I hate to interrupt, but I just wanted to ask Investigator Wentz that it was my understanding that there was possibly discipline in Wisconsin based on something other than this Colorado discipline.
So hang on a sec here. Which case are you referring to, Melissa? Are you referring to 1864?
Oh, I just had him all in front of me.
Yeah, because it says Wisconsin suspended it for inadequate inspection and inaccurate listing information.
Right.
So was something with Wisconsin.
That is correct. So on the actual case 2025-1864, the state of Wisconsin was failing to competently property inspection and listing information, and then it was actually disciplined from the other states that was listed on the case that was brought to the state of Washington. Correct.
So there is one new one. It's not just all Colorado.
Okay.
Correct.
And that's the only one.
That is correct.
Okay. So then I think we deal with that one.
So do we do
separately?
The and he reported it, right?
That is correct.
Okay.
So then that would be a $250 fine. Of course, then it's going to go round and round again to all the other states because we're fining him.
Right.
Yeah, I believe it's going to be kind of like a circular cycle as far as if the Real Estate Commission actually disciplines them on this, then obviously we're going to have other states that are going to
come back.
Exactly. So it seems like it's kind of like a just a vicious cycle.
Mm-hmm.
So do we go back to dismissal then?
Well,
but
where does he stand with us? Hang on.
It's active. He's active right now.
Active. It's his license under any discipline as far as probation or anything.
Nope.
I don't see anything.
I believe his discipline was from some cases in 2022. It looks like he had 1, 2, 3, 4, 5 in 6 different cases, and there was a stipulation and final agency order. He had.
I see all those.
I believe.
And he had a $17,000. That was us? He had a $17,000 fine.
I believe this individual is under stipulation, and that stipulation included 8 follow-up audits, if I'm not mistaken. And it is my understanding, on my limited knowledge of these, that the respondent has not been performing any real estate activity in the state of Colorado.
And I guess what would make a difference to me and maybe the other commissioners is knowing, and I may have to look back in this file, but was there anything that stated if he completed everything with us? Because I mean, he had a lot of education that he had to do. There was a $17,250 fine. He was suspended. He had a bunch of coursework. There was audits.
So did he complete that stipulation?
Did he complete everything, or is he still
I believe he still has one more of his follow-up audits to complete. And if you give me a moment,
Okay.
I can check that.
Okay.
But he hasn't really done any transactions in Colorado since that.
It's my understanding that the result of each of the follow-up audits was that the respondent is not performing any real estate activity in the state currently.
Yeah. Can we ask him to turn over his license? Instead of revoking it, if he's not really doing anything, can we ask him to, I'm drawing a blank at the moment what the word is, rescind his license?
Surrender.
Yeah. Can we ask him to surrender his license and then we'll quit all this circle stuff?
That is something I think that is an option that could be relayed to him. Certainly, I don't know if that's something he's going to accept or want to accept.
Yeah, he might want to keep it. I don't know.
And that is usually handled through our ESP department. So Penny usually assists with that. If a licensee would like to surrender their license in the midst of an investigation or an audit. So I don't know if he's given any indication or reason that he wants to. I believe the auditor that has done those audits is Betsy Meredith. I don't know if she's still on with us right now or not, but that's certainly something, like I said, I based on what I can see, he still needs to do at least his final follow-up audit, which would be his 8 out of 8 follow-up audits. And
so you're saying he's not doing anything, so there's absolutely nothing on the audit then?
He has continued to report that he is not performing any real estate activity in the state. And I believe the activity that he was performing that resulted in the investigations that turned into the stipulation and the follow-up audits, he is reporting that he is not conducting in Colorado as well.
Well, this
So
is
he
my
might not
thought.
just be doing anything out here.
I believe this individual is licensed in, I think, a majority of the states here in the country. So this is definitely something that is going to continue, given the amount of licenses that they hold.
This is my thought. Because it was brought to our attention that Wisconsin was a completely different issue. We handled that like we would normally handle it, which would be, reported the $250 fine, as Renee mentioned. The other two, we would do nothing because that's a result of the Colorado discipline that he already got here. And then if, you know, I mean, I know that this could create a cycle, but if he always could, this could go into the ESP process, right? Where he might at that point voluntarily surrender his license. I mean, that could come up as an ESP matter for us down the line if he wanted to stop the cycle. But because that one is new, which there's a lot of states, there's a lot to see. So I think a lot of us may have misunderstood that piece. And but because that one's new, I do think we just move forward with the discipline that we would normally do for a new violation. Thoughts on that?
Sounds good. Let's make a motion.
Okay. So motion, oh wait, hang on, let me get to the right page. Okay, so this is specifically for 2025-1864. Motion to impose the following disciplinary actions: diversion and a fine of $250.
Okay, do we have a second?
I'll second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes. That's for X. So
Yeah.
for Y and Z, we're just going to dismiss those, correct?
Yes.
So someone want to make a motion on,
Yes.
let's do them at the same time. Y and Z. Someone want to make
Yes.
a motion to dismiss?
Motion to dismiss complaint 2025-2134 and 2025-2390.
I'll second.
Okay, any further discussion? All those in favor?
Aye.
Any opposed? All right, motions pass for Y and Z. Now we are on to licensing matters.
And after license, I was gonna say either after licensing matters or before. Can we get like a quick little?
Okay, 10-minute
bathroom break?
break. Let's be back at 2:25.
Okay.
Okay.
Thanks.
Okay, let's see. We got Erica, Autumn. We're missing Bernadette. Oh, there's Bernadette. Okay, so we're gonna do licensing matters. We have 2 of those.
Yep. So licensing matter A is complaint number 2025-2091. This is an application. On December 11th, 2004, the applicant was convicted of motor vehicle theft, aggravated 2, amended to aggravated 1, under 15,000, a class 2 misdemeanor, which was then amended to a class 4 felony. The applicant was sentenced to 12 months probation, a fine of $782.79, and ordered to pay restitution of $4,757.79. The applicant has completed probation and has paid the fine and restitution in full. The case is closed. There's no recommendations, and Investigator Quinton is here to answer any questions you might have.
Hey, does anyone have any questions or like to make a motion on the application?
I just had, they didn't disclose the conviction, but it was in 2004. It was over 20 years ago. The applicant was pretty young, about 22. They've taken care of all their court fees. Restitution was paid, 0 balance, probation completed. We have letters of recommendation, letter from potential managing broker. I would give a positive recommendation.
Well, this is an application, so we're going to either approve or deny. So do you want to make a motion?
Well, does anybody else have any comments?
I have the same. I said the same thing. So I would approve it.
Yep, I would too.
So I would move to approve
Yes.
this application.
Okay, do we have a second?
Me.
Okay. Any further discussion? All right, all those in favor?
Aye.
Any opposed? All right, motion for approval passes. On to B.
All right, licensing matter B is an application. It's complaint number 2025-1672. The applicant has the following convictions. She has completed all sentencing terms and paid all fines. The applicant was released from parole in January of 2021. So she has false reporting, false identification, a class 3 misdemeanor, September 2018. Possession of a controlled substance, a class 4 drug felony, June 2018. Class 2 drug felony, controlled substance possession with intent, 7 to 112 grams, May 2018. Theft, a class 3 misdemeanor, June 2018. And then 3 separate cases resulting in 3 convictions of class 4 drug felony, controlled substance possession convictions in November of 2018. And also contraband, a class 4 felony. There's no recommendation, and Investigator Quintana can answer any questions.
Do you know when she actually got out of prison?
Yeah, so paroled in 2021. And then
Okay. Well, the letter from the employer, the builder, was an excellent letter as far as what she's doing now, and she's dealing with everything from payroll to everything else. So I would vote for approval on this one.
I apologize, guys. I had my sound turned off and I thought everybody was just waiting to come back. So I missed like a good portion of the conversation for the last 2 or 3 minutes, but I caught what Renee just said and I agree.
Any other discussion?
I would agree.
Okay, does someone want to make a motion?
I'll motion to approve application for licensure.
Okay, do we have a second?
Second.
All right, any further discussion? All those in favor?
Aye.
Aye.
Okay, any opposed? Motion passes. And now we'll move on to ESP matters. And I know Penny was around.
Good afternoon, everyone. First one for you is related to audit number X 2025-66. And this was a random audit, not a complaint issue. And when you guys reviewed this at your last meeting, actually, I think it was the meeting before, there was a question about some outstanding compliance with forms, so a violation of the 7.1. In looking at the materials that were actually submitted as part of the audit, it seems like the last submittal that was made by the attorney included both a copy of the original non-compliant along with the new compliant forms that were kind of overlooked. And so you weren't given that information back at that last meeting. Additionally, I think you all noticed that there was a discrepancy in the name of an attorney on the footer, and that raised some concerns to you, whether that was something that had been added by the respondent or just what was going on with that was a little unclear. So we did also obtain a letter from that office, or evidence that that office sent her a letter apologizing for that error in their footer and that there was nothing nefarious going on there. So based on this respondent's sort of cooperation with the audit and ultimately showing compliance, you originally had wanted a stipulation for diversion, $1,000 fine, and coursework and a follow-up audit, because at that point you thought she wasn't compliant. She is compliant. She did come to compliance during the audit, so there were things that were found. And so she is willing to accept and is asking if you will consider just a letter of admonition, which would be part of her record, and that she would waive her rights to an adjudicatory review of that letter of admonition.
Okay. Thank you, Penny.
Any discussion?
I thought we should accept the offer as presented.
Agreed.
Yeah, I agree. I think the only thing that she didn't do was just that one class on legislative updates. I think that was it.
Yeah, and just to speak to that, I have been unsuccessful in finding a class specifically on that subject matter. And if licensees stay current with their annual update courses, which this licensee showed me that they are, then they get the current legislative updates. So I thought I'd just add that.
Yeah, I thought about that because I figured with all of the with it being the beginning of the year, they would be doing some classes now, and I figured she'd get it with that. So I have a note that just said that we should accept it.
Okay, does someone want to make a motion?
I'll move to accept the offer with new information illustrated to consider and the counter proposal as listed.
Second.
Okay, any further discussion? All those in favor?
Aye.
Any opposed? Okay, motion passes.
Okay, the next one is regarding a continuing education audit, case number 2025-1496. And this individual was active when they entered into the stipulation. They're currently inactive, but they, again, were active, reactivated their license. It was a appropriate continuing education audit. They were non-compliant. They agreed to pay a fine. They agreed to do some coursework, and they have done neither. And so the stipulation that they did enter into says that if they fail to comply with that, that the next step would be formal discipline. So our recommendation is to move forward with a final agency order, a public censure, a fine of $2,500, and a 30-day suspension to continue until compliance. And that means compliance with both the original order that they already signed and then this new action as well. We would want full compliance to remove the suspension. In a case where this may be a question, so I'll anticipate it. In a case where somebody is currently inactive, we wouldn't necessarily suspend their license, but if we were to proceed with an action, we would ask for that 30-day to be upon reactivation, then they would have their period of suspension.
Do we need to change the verbiage on that, on the recommendation or not?
I think if your recommendation is for a 30-day suspension and to continue until compliance, that's enough. We just know that we're going to suspend an active license, not an inactive license. So I don't think you need to change the verbiage. I just wanted to give you that clarity.
All right, any discussion, or does anyone want to make a motion?
Motion to accept the staff recommendation.
Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes.
Okay, so the next one is case number 2024-1209. They signed a stipulation back in July of 2025. It was a practice related. You can see the violations listed there. They agreed to a fine of $3,450 and some coursework. And they did complete the coursework, but they have not and made one payment. They asked for a payment plan, and we offer payment plans whenever people ask us, because our goal is to help them get compliance. So they did make one payment, but then they haven't followed through since then. And again, they signed an agreement that said if they fail to comply, they acknowledge that the next step is, and that's why we're seeking a final agency order, public censure, a fine of $2,500, a 30-day suspension to continue until compliance is met with both the original order and this action. And they are active currently.
Thank you. Quick question. So I'm sorry, is the coursework completed or no?
Yes.
Yes. The
Okay.
coursework is completed.
Okay, because I saw that it was, but then I was looking at, I think, number 4
And-
made me think that there was a conflict of information there. So, okay.
Yeah, I had my the staff that tracks these for me, I had them yesterday. They go through these, and this morning I got an email that there's no new information.
Okay.
So the coursework is completed, but the fine is still outstanding.
Okay, any discussion or anyone want to make a motion?
Well, just a brief discussion. And I don't know that it is of our concern, but reality is, and if they weren't able to pay the fine on the payment plan, they're probably not going to be able to pay this fine. So it kind of enters into another like cycle of stuff. Maybe just a note. I don't know. I mean, we can continue to add fines, but if they can't pay, maybe because of business or whatever, they can't, I don't know that it.
We're gonna see
you
this
know,
on all these though that are coming up.
Mhm.
and you know, every once in a while that is the discussion that I have with somebody, and they say that, you know, they say, oh, I'm not even working, I can't pay this. And oftentimes at this stage, we would negotiate a settlement, go ahead and pay the original fine that you already signed a contract to. You've already agreed to that. We expect you to follow through with that. And then if they want to surrender their license, they can do that, and we would stay the fine. We wouldn't impose that at this time. So, you know, we do have a variety of ways that we can sort of work through these issues with people.
And then I'm assuming that when this individual didn't make the payment, there was some sort of, I mean, it says here there was outreach to them, like, hey, to make your payment, and then they just stopped communicating. Is that is that how it happened, or have they asked to extend that?
You know, we'll see a variety of things. And again, my staff is instructed to, I would much rather have compliance, even if it takes longer, than to go through this process. So that's why sometimes you'll see some of these that have been going on for quite some time, because if people are communicating with us and in good faith trying and making some payments, we continue to work with them. When they kind of stop communicating, we feel that it's, you know, we're obligated to enforce the contractual agreement that we came under when they signed the stipulation.
Yeah. Okay.
So,
It was really just a comment, is because it's kind of too bad. It seems like this person, you know, is trying to get on track, but, you know, can't pay the fine, but that is beyond our control, I guess.
well, if based on this decision, and this individual gets this, or any individual gets this decision, because it'll get mailed out from me, I will send them the decisions from this meeting. And if somebody, you know, makes good on their original action and says, oh, my bad, can we please reconsider this? If you'd like to see those come back before you for reconsideration, I can certainly do that. I feel like, you know, the commission staff works tirelessly to work with these people to try to gain compliance, and grants extensions and extensions and extensions. And
And I know it's hard once communication stops, right?
it is hard once communication stops.
Yeah. I just wanted some insight as to these scenarios, because
I've had lots of conversations with people begging them, like, this isn't going to get better. Please, you know, work with me, do a payment plan, do something, pay $5 a month, you know, something. And, you know, we can only do what we can do.
Yeah. Okay. With that being said, I'll motion to accept the staff recommendation.
Okay, do we have a second?
I'll second.
Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes.
Okay, the next one is case number 2024-1036. They signed the stipulation back in July. Ordered $4,600 in fines and a variety of coursework, none of which have been completed. And again, stipulation says the next steps. So our recommendation is to seek a final agency order, public censure, $2,500 in fine, and a 30-day suspension, and to continue until compliant with both the previous order and this new action.
Okay, someone want to make a motion?
I just had a question. I think I had a question on this one. Sorry, I'm trying to get to my notes. I think there's a couple of these that this question is going to be relevant to, so we just get it out the way now. When we're having trouble reaching them and there's just no response, do we send by mail too, or are we just sending emails?
We are sending emails. If it is an associate broker, we also communicate with the employing broker. This is an employing broker. and we are trying to reach them by telephone as well. I'm looking at Cynthia's notes here, and if in cases where we have a good email address where we've had some communication, for example, the email that they worked with me signing the stipulation, we continue to use that email. If we were to get a bounce back and it's not getting through via email, then we would go ahead and mail it.
Okay. I'm just, again, this comes up. I think there's a couple that it was just no communication whatsoever. So I was just making sure that because obviously someone's license and emails can be, they can go to junk folder and who knows where. So I just want to make sure that we are making other attempts other than email when when they're not responding that way. So at least mail, they have it in paper,
Yes.
Okay.
And
I have a question. So this is, we said, this is an employing broker, and we would be suspending their license until the compliance is met. Do we know how many brokers are underneath them that this will affect their license?
I don't, but I can, if that's something you need me to look up, I can certainly do that.
Because how would they all just be notified that their license is?
Yeah, in cases where we are going to suspend or revoke, the license of an employing broker, hang on one second. Let me just see what he's got. I'm having my blood sugar's low. I'm having a hard time talking and reading. It appears as though he does not have anybody under him.
Okay.
It's a company, but he doesn't have anyone under him. I know that, there are, and I can't say, gosh, I'm trying to think of the last time we've had a really big, an ER with a big company go down. But I know that when there's, there are attempts to reach out to and make sure that associate brokers are aware that the employing broker is going to go down. We talk to employing brokers about that to make sure that they let their people know. So, we mitigate where we can there, but we're hoping that the employing brokers are communicating.
Yeah, because I'd hate to see somebody come in front of us and them say they didn't know that, their license is suspended and they're practicing, and because they don't have an employing broker or something happens when they have an opportunity to go find somebody else. It's just lack of communication.
Yeah, I believe a notice goes out when their license becomes inactive because of the lack of a employing broker in place. But I can't, and I'm only, I think, 19 years in, so not a lot, but I can't think of a time where a commission has disciplined an associate because they were inactive because their employing broker went down.
Okay.
So there's some mechanisms in there that help us not have that be a problem.
Okay. Thank you.
Sure.
We'll move to accept staff recommendation.
May I have a second?
Well, second.
Any further discussion? Okay, all those in favor?
Aye.
Any opposed? Okay, motion passes.
Okay, the next one is 2025-1200. This was stipulation signed in August. It was a continuing education audit, and they were required to pay a fine, do some coursework. They have done none of that. Since then, they have gone inactive. And again, their stipulation said that if they didn't comply, the next step would be formal discipline and max fine. So we're seeking public censure, final agency order, $2,500 in fine, 30-day suspension to continue until compliant with previous and current order.
You said this is they're inactive though right now?
They did inactivate, yes. They were active during the audit and signing the stipulation, and then inactivated. I think sometimes, again, people think that means they don't have to do anything.
Okay. All right, motion to accept staff recommendation.
We have a second.
I'll second.
Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Definitely having a run on non-compliance right now, so.
Yeah.
Yet another non-compliance. This one is case 2025-1787, signed in October, resulted from a continuing education audit. They are active. They agreed to pay a fine and to do some coursework and have done neither. And again, seeking final agency order, public censure, $2,500 in fine, and a 30-day suspension until compliant with the previous order as well as this action.
Motion to approve staff recommendation.
We have a second.
Second.
Any discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Okay. This one is case 2023-2435. And this was actually a final agency order that was entered into, so not a signed stipulation. This was a litigated action, and that order called for a fine and coursework, and that the license would be suspended until the coursework was completed. The order did put a 30-day window on the fine, and that has not been paid. Their current status is suspension, but it appears as though this individual may not have any interest in their license, is not participating. So we are seeking or recommending a final agency order, public censure, revocation, and a fine of $2,500.
And this is, I think, one of the examples I was talking about, because they didn't sign a stipulation. So it's safe to say that they probably weren't communicating when the original.
I believe so. This one is, I believe they signed, and let me pull up her file so that I'm telling you the exact, because I know, I believe this one was signed the original stip, didn't comply with it, got a violation of that order, but let me double check because I might be confusing her.
It was an FAO to start with. It was an FAO.
I thought it started as a FAO, which is
so they don't have to sign.
Which means, right, they may not have participated in anything.
Right.
We've had some communication. At some point she and I did speak.
Oh, okay. Okay.
But
I was just just again curious about that. Not that it changes anything, but revocation seems definitely appropriate at this point. So.
Okay, you want to make a motion?
Yeah, motion to accept staff recommendation as presented.
Okay, do we have a second?
I'll second.
Okay, any further discussion? All those in favor?
Aye.
Any opposed? Okay, motion passes.
And this brings us to our next one, case 2023-2083. And this also was a final agency order after litigation. And there was a fine and coursework ordered, same thing. remained suspended until the coursework was done. Fine was due in 30 days. Neither have been addressed. Current status is suspended and seeking the same thing. Final agency order, public censure, revocation, $2,500 in fine.
Motion to accept staff recommendation.
We have a second.
Second.
Okay, any discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Okay, and the next one, matter I'm going to pull a success story through multiple phone calls and conversation. We did get compliance ultimately achieved, so we are don't want to pursue any further action in that situation. And so the last one is J, and this case is case number 2024-668. And this is another final agency order through a litigation process. There was a fine, there was coursework, there was a suspension until coursework was completed, 30 days on the fine. Neither have been addressed. So again, just seeking final agency order, public censure, revocation, and $2,500 in fine.
Okay, motion to accept staff recommendation.
Okay, do we have a second?
I'll second.
Any discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes.
That is all I have for you.
Thanks, Benny.
Thank you.
Okay, anybody have anything else?
No, and mine just placeholder, so disregard mine, Attorney General matters.
Okay. All right. Okay, and I guess we are adjourned until the next meeting, which is April 7th, 2026.
All right.
Thank you, everybody.
Thank you,
Thank
everybody.
you.
All right. Have a good one,
See you in a
everybody.
couple months.
Bye.